Good morning, everyone. We request all the dignitaries and guests to please take your seats. Honorable Chief Justice is going to arrive in a short while, so please settle down in your seats. Dear audience, Honorable Chief Justice is already at the venue. We request all the persons and dignitaries and guests who are standing and not yet occupied the seats, please settle down. And we expect a silence from all the audience. And now we will start playing the audiovisual of the Bar Council of Andhra Pradesh.
Bar Council of the State of Andhra Pradesh welcomes you all. Formation of AP Bar Council. Under Section 3 of the Advocates Act Bar Council of the State of Andhra Pradesh welcomes you all. Formation of AP Bar Council. Under Section 3 of the Advocates Act 1961, there shall be a Bar Council for each state, and accordingly, the Bar Council of Andhra Pradesh has been constituted. The AP State Bar Council has statutory duties of enrollment of law graduates, regulating legal practice of advocates, initiating action against erring advocates, welfare activities, and schemes for advocates. AP Bar Council location. In erstwhile Andhra Pradesh, Bar Council of Andhra Pradesh office was situated in Hyderabad. After bifurcation, Bar Council of Andhra Pradesh office was shifted to Amravati, now is situated at AP High Court building, Nelapadu, Amravati. Governing body of the Bar Council of Andhra Pradesh. As per the Advocates Act, the Bar Council of Andhra Pradesh consists of members who are elected for 5 years, an Advocate General of AP who is an ex officio member, and the council elects its chairman and vice chairman and VCI members. According to Clause B, subsection 2 of Section 3 of Advocates Act, a state bar council with an electorate exceeding 10,000 advocates shall consist of 25 members. Activities. Activities of Bar Council of Andhra Pradesh include enrollment of law graduates, Bar Council of the State of Andhra Pradesh welcomes you all. Formation of AP Bar Council. Under Section 3 of the Advocates Act 1961, there shall be a Bar Council for each state, and accordingly, the Bar Council of Andhra Pradesh has been constituted. The AP State Bar Council has statutory duties of enrollment of law graduates, regulating legal practice of advocates, initiating action against erring advocates, welfare activities, and schemes for advocates. AP Bar Council location. In erstwhile Andhra Pradesh, Bar Council of Andhra Pradesh office was situated in Hyderabad. After bifurcation, Bar Council of Andhra Pradesh office was shifted to Amravati, now is situated at AP High Court building, Nelapadu, Amravati. Governing body of the Bar Council of Andhra Pradesh. As per the Advocates Act, the Bar Council of Andhra Pradesh consists of members who are elected for 5 years, an Advocate General of AP who is an ex officio member, and the council elects its chairman and vice chairman and VCI members. According to Clause B, subsection 2 of Section 3 of Advocates Act, a state bar council with an electorate exceeding 10,000 advocates shall consist of 25 members. Activities. Activities of Bar Council of Andhra Pradesh include enrollment of law graduates, facilitating welfare activities, and conducting disciplinary committees. Here is an epitome of orientation programs conducted by Bar Council of Andhra Pradesh every month on legal topics by eminent jurists in several districts of Andhra Pradesh for the benefit of advocates. Addressed by esteemed High Court judges, one-day seminars were successfully conducted by Bar Council of Andhra Pradesh at Visakhapatnam, Eluru, and Narsapuram. Digital automation. The Andhra Pradesh Bar Council offers automated digital services to advocates via its website and mobile app, allowing them to access services at their fingertips. Launch of e-services. The AP Bar Council launched an app to put its services at the fingertips of advocates. Advocates can check their enrollment, welfare, and COP details on the app itself. Advocates can register in the app and can get updates on upcoming seminars. Advocates anywhere through the app. Legal news and latest updates of Bar Council of Andhra Pradesh and BCI and legal articles will be posted frequently in the app for the benefit of advocates. Vision of Bar Council of Andhra Pradesh. The vision of the Bar Council of Andhra Pradesh is to launch a single window system for easier communication and to bring transparency and accountability among advocates, associations, and council. Thank you.
Now we request the audiovisual file of the KL University to be played.
With campuses in Vijayawada and in Hyderabad, the capital of startup state Telangana, KL University employs higher-order teaching pedagogies, driven by globally renowned faculty. State-of-the-art research department with additional focus on industry-driven skilling have been paramount in attracting 500-plus MNCs to engage with KL, resulting in a track record of 100% placement.
At KL University, we concentrate on overall development of the student. Along with the academics, we give equal importance for all-round development of the student.
The faculty of KL is made up of eminent faculty from premier institutions in India and across the globe. With more than 500 faculty holding PhDs and 550 more pursuing PhDs, KL leaves no stone unturned in edifying higher education. Academics at KL are divided between our faculty and a roster of acclaimed international and guest faculty. The usage of teaching pedagogies like flipped classroom, project-based learning, empirical learning, and deep and blended learning. Faculty at KL certify a holistic education for every student. While taking the class allows students to receive a more hands-on education, which leaves them with a deeper understanding of concepts and practices. Our fully flexible choice between the credit system empowers the student to hold the reins of their education. Again, it's about adding another dimension and expertise to a student's arsenal. We keep our eyes on the future, while our feet firmly rooted in the present. In an exciting association with National Skill Development Council and engaging the best in the industry and domain experts, KL has introduced methods to educate students in skills necessary for the future, like big data and analytics, Internet of Things, artificial intelligence and machine learning, cybersecurity and forensics, applied signal processing, robotics, renewable energy, and many more. Technical clubs in all the departments allow students to interact with like minds and go further. Research in all domains is given as much importance as academics. KL is at the forefront of industrial and academic research, with 2,000 plus active researchers, 7,000 plus research publications, and 50 plus patents. Needs of the common man are the most important threats of KL. Be it our research in big data, helping us to map out weather patterns to enhance satellite communications, or map DNA. The government of India supports our endeavors fully, as evidenced by their aid in the form of more than rupees 40 crore. Everything at KL is geared towards providing our students a clear shot at their dream career. All registered students placed in companies, resulting in our proud 100% placement rate. More than 50 companies have offered salaries larger than 5 lakhs a year. KL provides launch pads for the career progressions of every individual student. Coaching and mentoring services are available for GRE, TOEFL, IELTS, GATE, and civil service. To further hone the entrepreneurial spirit, we have a government-sanctioned business incubator and center for innovation and entrepreneurship to nurture student-led startups.
And also want students from higher education. So I think the students also want to do the master's program. So we also have GRE coaching at the University of
Life at Kenya is a hustle of 9 times spent with like-minded in an environment conducive to creativity and growth. We host national-level techno and cultural fests, where students are given a platform to display their talent and more than 70 hobby clubs to explore said talent. They stay fit at our world-class sports arenas and gyms. And nourished at their choice of 8 multi-cuisine cafeterias. It has formed partnerships with over 64 foreign universities with exchange programs to deliver a truly global exposure to our students. Semester abroad and twinning programs give the students a global exposure. With its sights set far above the horizon, KL is bringing global education to everyone with their launch of the new campus in Hyderabad. Designed by the world-renowned architects Woods Bagnet, the state-of-the-art campus is being built to international standards. It's easy to be part of the crowd and follow, but it's difficult to be different and stand out. At KL, we do not believe in simply teaching. We believe in creating global personalities who stand out with KL. KL, deemed to be university.
Good morning, everyone. A warm welcome to all the distinguished dignitaries, honorable judges of High Court of Andhra Pradesh, learned Advocate General, Chairman and members of Bar Council, Honorable Chancellor and Vice Chancellor of KLEF, faculty, senior advocates, press and media, and advocate delegates who have come to this residential orientation program for advocates. Have it has been our own practice to commence any program with an auspicious event. Therefore, I now request Shanmukhi Janadula, a first-year student of BBA LLB at College of Law, to perform a dance on Ganpati Gotram.
Wow, that was indeed miraculous. Good morning, ladies and gentlemen. Warm welcome to KLEF Deemed to be University, Greenfield, Swadeshwaram. KLEF College of Law, a constituent unit of KL University, is pleased to be associated with the Bar Council of Andhra Pradesh in organizing this 3-day residential orientation program for all the advocates. This is Dr. K.I. Pavan Kumar, Associate Professor, KLEF College of Law.
And this is Mudassir Rasool, Assistant Professor, KLEF College of Law. We extend our heartiest welcome to the honorable judges, advocates, academicians, research scholars, and students attending the program.
During this 3-day orientation program, there are too many takeaways to all the participants. Like, we're going to learn the insights of AIs with reference to CPC, important provisions of Indian Evidence Act.
The event will also feature lectures on other aspects of law, including courtroom practices in receiving oral and documentary evidence, techniques for managing stress and winning in life, interpretation of statutes, the art of cross-examination in criminal trials and Motor Vehicles Act, and other aspects of law.
So why to make a delay? Now let us proceed with the proceedings of this session. Now I request to play the audio-visual profile of Sri Ghanta Ramarao Garu.
Sri Ghanta Ramarao Garu combined his legal career with a burning passion for justice. His journey began when he enrolled as an advocate in 1984 after completing his LLB degree from MVP Law College, Visakhapatnam. For an impressive span of 5 consecutive terms, since 1995, Ghanta Ramarao Garu was elected as a valued member of the Bar Council of Andhra Pradesh. Recognizing his exemplary track record and leadership abilities, he was subsequently elected as the inaugural chairman of the Bar Council of Andhra Pradesh in 2018, following the bifurcation of the state. Under his leadership, along with the cooperation of other members, the Bar Council of Andhra Pradesh has successfully introduced initiatives to enhance legal education, provide legal aid to the advocates, and promote equality within the legal profession. His dedication and tireless efforts have significantly contributed to the growth and development of the legal landscape in Andhra Pradesh. We are honored to extend a warm welcome to Sri Ghanta Ramarao Garu, Chairman of Bar Council of Andhra Pradesh.
Now we request Sri Ghanta Ramarao Garu, Senior Advocate, Chairman of the Bar Council of Andhra Pradesh, to come on to the dais and preside over the session. We also request Ms. Ashrita to accompany the guest, please. Welcome, sir. Good morning. Now I request Dr. Kamasai Garu, Associate Professor, to offer sapling to the Honorable Chairman, Sri Ghanta Ramarao Garu.
We now request to play the audio-visual profile of Honorable Chief Justice Shri Prashant Kumar Mishra, Chief Justice, High Court of Andhra Pradesh.
The judiciary is the backbone of a democratic society, and the people who preside over it must have a keen sense of justice, exceptional legal knowledge, and an unwavering commitment to upholding the rule of law. And today, we have the privilege of welcoming one such person. Honorable the Chief Justice of the State of Andhra Pradesh, Shri Prashant Kumar Mishra. Justice Mishra has had a distinguished career in the legal profession, which began when he enrolled as an advocate in September 1987 after completing his BSc and LLB degrees from Guru Ghasidas University, Bilaspur. Justice Mishra has been involved in legal practice across various courts, including the District Court of Raigad, the High Court of Madhya Pradesh at Jabalpur, and the High Court of Chhattisgarh at Bilaspur, where he dealt with civil, criminal, and writ branches of law. Justice Mishra was appointed as the Chief Justice of the Andhra Pradesh High Court on October 13, 2021. He has already made significant strides in promoting the rule of law and ensuring that justice is accessible to all. Honorable the Chief Justice Mishra's commitment to the legal profession and the rule of law has been recognized by his peers and colleagues, and he has received numerous accolades for his contributions. Today, Bar Council of Andhra Pradesh and Kerala University are honored to welcome you, sir.
We now request the chief guest of today's function, Honorable Sri Justice Prashant Kumar Mishra, Chief Justice, High Court of Andhra Pradesh, to be pleased to grace the dais and adorn the chair. We request Ms. Pranita to accompany the Honorable Chief Justice to the dais. We now request Sri S. Brahmananda Reddy Garu to present a sapling to His Lordship.
Now, we request to play the audio-visual profile of Honorable Sri Justice Akula Venkatesha Sai garu.
In the halls of justice, there exists a remarkable figure, an embodiment of wisdom, integrity, and compassion. He is none other than Honorable Justice Sri Akula Venkatesha Sai, a distinguished judge of the Andhra Pradesh High Court. Justice Shesasai has had an illustrious journey in the legal profession, which began when he enrolled as an advocate in 1987 after completing his LLB degree from Sri C.R. Reddy College, Oruru. Honorable Justice Shesasai actively practiced in civil, criminal, services, constitutional and almost all other branches of law, had developed his independent practice within short span of time and extensively dealt with number of cases covering all branches of law. Honorable Justice Shesasai was elevated as Additional Judge of High Court of Andhra Pradesh and sworn in on 12/4/2014. Appointed as Judge of the High Court of Judicature at Hyderabad for the state of Telangana and the state of Andhra Pradesh and assumed charge as such on 8/9/2014. Born with a deep-rooted passion for law and justice, Justice Shesasai has consistently made significant contributions to the legal field throughout his esteemed career. The legal fraternity is fortunate to have a luminary like Justice Shesasai, whose legacy will continue to inspire and guide generations to come. With great honor, we welcome Honorable Justice Sri Shesasai.
We request the guest of honor of today's function, Honorable Sri Justice Akula Venkatesha Sai garu, Judge High Court of Andhra Pradesh, to come onto the dais, and I request M. Subbarao garu to offer sampling to the Honorable Justice Sri Sesh Sai garu.
We now request the technical team to play the audiovisual profile of Honorable Chancellor KLEF University, Sri Koneru Satyanarayana Garu.
He is the man who believes serving human is serving God. The man who changed the face of technical education in Andhra Pradesh. An academic evangelist, philanthropist, industrialist, and educationist par excellence. Koneru Satyanarayana is well known for his contribution to the field of education through Koneru Lakshmi Education Foundation deemed to be university, popularly known as KL University. Engineer by profession, entrepreneur by choice, and dedicated to change the destiny Koneru Satyanarayana has influenced, inspired, nurtured young minds by establishing Koneru Lakshmi College of Engineering along with his father in the year 1980. Born on 20th October 1954 in Vijayawada, he completed his schooling from Montessori Public School in Vijayawada, and he completed 10th class from Lala College in Vijayawada. He graduated in Electronics and Communications Engineering from BMS College, Bangalore in 1977. Soon after he graduated, Koneru Satyanarayana began his career as entrepreneur by establishing the Postal Cable Private Limited. In the year 1977, he established 15 companies spread across various sectors. He's shaping young minds, infusing them with leadership, sincerity, and professionalism were integral part of Koneru Satyanarayana's leadership. Creating industry-ready engineers with a fire, innovation burning within them was a challenge that Koneru Satyanarayana accepted and handled effortlessly to his institution. He was quick to understand that empowering students and transforming them into agents of change was instrumental in the development of higher education. Koneru Satyanarayana was the first person to introduce computer science engineering in the year 1983, industrial production engineering in 1983, information science and technology in 1997, electronics and computer science engineering in 2001, and biotechnology in 2004. In private engineering college in Andhra Pradesh is a typical example of his futuristic thinking. Here, KL University has many place. The contributions made by Sri Koneru Satyanarayana are simple yet eminent towards humanity are worth mentioning. His activities and thoughts guided the society to a new beginning. ఎడ్యుకేషన్ గురించి ఎంత మాట్లాడుతున్నాను నాకు ఇష్టం, నాకు ప్యాషన్. నేను నా దగ్గరకు ఒక స్టూడెంట్ వస్తే ఆ స్టూడెంట్ బయటకు వెళ్ళి అతనికి 40 లక్షలు 50 లక్షలు శాలరీతో బయటకు వెళ్ళినప్పుడు ఆ స్టూడెంట్ ఆ పేరెంట్ వచ్చి నా దగ్గరికి ఎంత బాగుందని నాకు చెప్పినప్పుడు నాకు అసలు చాలా హ్యాపీగా ఉంటుంది.
We now request Honorable Chancellor KLEF University Sri Koneru Satyanarayana Garu to grace the dais and adorn the chair. We request Ms. Khyati Priya to accompany the Honorable Chancellor to the dais. We now request Sri V. Chandrasekhar Reddy Garu to present a sapling to the Sri Satyanarayana Garu.
Now I request the Honorable Vice Chancellor. No audio video.
We now request the Honorable Vice Chancellor, KLEF University, Professor Dr. G. Pardasarthi Varma, to come to the dais and adorn the chair. We request Ms. Pravalika to accompany the Honorable Vice Chancellor to the dais. We also request Sri V. Brahma Reddy Garu to present a sapling to the Honorable Vice Chancellor.
हो गया ना? Yeah. Before I request Sri Ganta Ramarao Garu to take over the proceedings further, on behalf of KLEF College of Law and KL University, we wanted to ensure that for the sake of maximum convenience to all the participants here, our KLEF students, student volunteers, faculty members are stationed at various locations, both inside and outside the auditorium. They can be identified both by their black and white color dress as well as by their ID cards. So anyone needs any kind of help or assistance, please do not hesitate to reach to us. We are at your disposal. Now I request Sri Ganta Ramarao Garu, Chairman, Bar Council of Andhra Pradesh, to take over the session. Thank you.
Thank you.
Prayer by Santosh Shanmuki.
वन्दे मातरम् वन्दे मातरम् सुजलां सुफलां मलयज शीतलां सस्यश्यामलां मातरं वन्दे मातरम् सुप्रज्योत्स्ना पुलकितयामिनी पुल्लकुसुमिता द्रुमदलशोभिनी सुहासिनी सुमधुरभाषिणी सुखदां वरदां मातरं वन्दे मातरम् कोटि कोटि कंठ कल कल निनाद करारे कोटि कोटि भुज धृत कल कल वारे अबलांकन माय बले बहुबलधरिणी नमामि तरिणी त्रिपुरनवरिणी मातरं वन्दे मातरम् तुमि विद्या तुमि धर्म तुमि हृदि तुमि वर्म त्वं हि प्राणा शरीरे बहुदे तुमि मा शक्ति हृदये तुमि मा भक्ति तोमरई प्रतिमा घड़ी मंदिरे मंदिरे वन्दे मातरम् वन्दे मातरम्। जय हिंद।
Now the lighting of lamp by the dignitaries. The Honorable Chief Justice, Prashant Kumar Misraji, Honorable Sri Justice Akula Venkateshwara Garu, Sri Honorable Chancellor Sri Koneri Satyanarayana Garu, the Vice Chancellor, the members Bar Council, Justice Setaram Murthy garu, the senior advocates, delegates, faculty members of KL University, staff of the KL University, ladies and gentlemen and media friends. This is a very auspicious occasion. So many people registered. In fact, after closure of also, they requested and got them enrolled. It shows their interest to improve their knowledge. As a part of continuous education, the Bar Council of Andhra Pradesh, even before its bifurcation, have been taking up this kind of residential orientation programs. In the first nearly 15 years back, with the 100 people, an experiment was made in Aware campus in Sri Salem Road near Hyderabad. And nobody knows what is the program. And everything is uncertain because it's the first of its nature. But all the 100 people stayed there for 3 days. In spite of so many difficulties, because single phase connection is there, always frequent power cuts during May and night also. Sometimes we went to the lawns and by laying the bed sheets we slept in the night time. In spite of so many shortcomings, 3 days, they continuously participated, and then we realized importance of this kind of programs. Thereafter, with in cooperation of the successive Chief Justices, we are able to conduct this kind of program in Nalsar University. Around 4 times we conducted there, and thereafter with the cooperation of ICFI University. And one such program was conducted in Andhra Pradesh, and another is at Nagarjuna Sagar, in near Vijayawada. And we are also conducted in Island, Bhavani Island. Nearly 375 people attended for that. By traveling from the boat to the island, and they stayed till night, 8 o'clock, 9 o'clock. It went on for 3 days. After bifurcation taken place, then we have planned to conduct this kind of program at Visakhapatnam. Same could not be materialized on account of widespread virus. After this virus was controlled, we are able to conduct programs, one-day seminars at Visakhapatnam, Eluru, Narsapur, and we have planned each month now we have to conduct 2 programs. We have decided in the Bar Council, and with the cooperation of all my friends in the Bar Council, we will be continuing these kind of programs. This program is a unique program because all the compared to the earlier programs, and one distinguished feature is, since long time we have been trying to involve the Honorable Chief Justice, but somehow or other we missed the opportunity. All these occasions. Today we are fortunate. Honorable Chief Justice is with us, and in spite of his busy schedule, because he is supposed to leave the station on account of this vacation, but Honorable Chief Justice Garu accepted our request and postponed his program and accommodated us, and we are thankful to his lordship. On the KL University, the moment we went and met the Chancellor, and he extended in such a way that each and every one of the persons who are involved, they are feeling that as if this function belongs to them, as if some function is going on in their house. Very meticulously, every minor things are taken care of. You will be very happily, you can assure you, because on their behalf, you will stay here very comfortably. And above all, any program to be successful, it is the participants who shall cooperate. My dear friends, your cooperation now will make these kind of programs again and again. Please kindly cooperate with the organizers. These 3 days you have to spend differently. Whatever we are having, other breaks, let us don't leave the premises, don't destruct any tree or plantation. please kindly cooperate how much pains they take to maintain this greenfield university. Therefore, we have to extend our cooperation in the first place, not to damage anything, not to interfere with the nature. And second is, extent possible, we will think over that. And apart from the legal subjects, you will be having opportunity here to various aspects and to manage the stress, to improve the communication skills. Number of undisclosed programs will be also there. No doubt we will take a hectic session till evening. Evening after you are again fresh up, you will be entertained with the cultural program so that you can be relaxed and get ready for tomorrow. Apart from that, my dear friends, all these days, what I observed is many people have many doubts, but they don't express because somebody may feel bad about it. Maybe fundamental things, small things, basic things, but those doubts are still continuing in our minds. Therefore, to dispel that, we are making some experiment. You need not disclose your name. We are putting a box here called as a doubt box, and people are whatever silly doubt that is relating to the profession, relating to any particular subject which is there in the today's program, this 3 days program, and even relating to some subject which is not belong to any one of the topics, so that that can be clarified and we can leave this campus with the satisfaction that all those remaining doubts in your minds are clarified. And once again, I appeal to all of you, you accommodate the persons who are right and left, allow them to enjoy the program, and keep cool, calm, switch off all the cells or at least silent mode, and keep away from all that anxiety and everything, and coolly, and take this opportunity, and differently you will spend here these 3 days, forgetting everything, and pay all your attention towards this program only. Thank you. And again, I take this opportunity to thank the Chancellor, the Honorable Chief Justice, who has already made his efforts and sacrificed for us his holiday, and also thank the Chancellor and the Vice Chancellor for taking a keen interest in conducting this program successfully. Thank you. Thank you, one and all. Now I call upon the Honorable Vice Chancellor to give the welcome address.
Dignitaries on the dais, my dear guests, delegates of 3-day workshop, press and electronic media, warm welcome to all of you at this place. It's a great pleasure for all of us to welcome you, and we feel it is our function to host this in the campus, and we are fortunate enough to hosting all of you in the campus for this 3-day workshop of the Bar Council at this place. And to have a technical sessions and to have a nice presentations at this place from last, there's a discussion and there are a lot of teamwork was done from the Bar Council from last 3 months actually, and that was speeded up from last 1 month actually, and our teams are already collaborated, and Yale University and Bar Council is conducting this event in this place, and we are fortunate enough to host all of you in the campus, and we're ready to we are hosting every one of you at this place. At this juncture, I'd like to mention that actually the Yale University is meant for educating the students in this place, and started the journey in 1980, and 43 years of journey. It produced almost world-class engineers all over the world, and every nook and corner of alumni are there actually sharing the workforce all over the world. And proved the best of its kind, and produced almost 5,000 50,000 alumni at this place and engineers. Out of that, actually 5,000 entrepreneurs and almost 1,500 CEOs, vice presidents, and all those was proven to the best track record. That was the brand image of the campus. That made us to the top universities in the India. We are ranked top 27 in India by MHRD. It is a continuous process every year. They give the ranking. When this ranking, it is actually national in the national ranking framework. We are there in top 27 actually out there. Not only in national wide, we are there in international rankings also. When times the world education ranking is the top, world ranking, and QS ranking is world ranking out there. We're there in top 400 to 600 brand out there in this process. And that is just because the students produced from this campus was performing well outside all over the world, and that proven to the best of its kind at this place. Not only that, actually, this campus is a green and smart campus. 3 times we won All India first in smart and green campuses in the process by MHRD at this place. And the infrastructure in this place is international standards at this juncture at this place. And we are committed to provide the career for the student. It may be the placement, it may be internship, it may be innovation, it may be higher studies, it may be a research and a government job at this place. And in that process, 360 degrees of development activities was taken care of the campus at this place. And in the placement, we are top actually in the best package, the topmost package is 60 lakhs package in national wide. International wide, the package is actually 98 lakhs. We already placed several students in international placements also. And 98 lakhs is the highest package in international placements, and nationwide it is 60 lakhs is the highest package at this place, and more than 46 lakhs package, almost 35 numbers was placed actually, and more than 20 lakhs, almost 400 numbers was placed, more than 10 lakhs, 800 numbers was placed, more than 5 lakhs, almost 1,800 students was placed every year at this place. When we inculcate the skilling at this place, it's not a degree-oriented test, it is skilling-oriented campus. We give all types of skilling at this place, and our campus was having all types of courses except the paramedical, we have law, we have architecture, we have pharmacy, agriculture, sciences, food sciences, and sciences, and MHS, humanities, and we also have the engineering campus are there. And we have off campuses in Hyderabad, 3 off campuses, Global Business School in Hyderabad, and Bachpally we have 1 campus, and Upper Junction we have 1 more campus at this place, Aziz Nagar campus it is. Overall, this campus, we have almost 20,000 students all over India, and working out the best of its kind. And we give a lot of preference to the research at this place. Top 2% of researchers in the campus, we have 12 numbers. World-renowned researchers of top 2% in the world, it's given by Cambridge University. We have 12 members in this place. We are fortunate enough to have them actually. We publish papers. We're there in top 20 in publishing papers are there. We have almost 50,000 publications in the campus. Our H-index is almost 69 actually here. Citations is almost touching 1 lakh at this place. And book publications and chapters, several occasions, several things are there in this process. We have funded projects all over, grabbed from government organizations, and already the international universities also, international funding agencies also fund this the research activities in the campus. So we have incubation centers in the campus funded by Government of India. In TBI and ACIC, we give a lot of preference to the entrepreneurship at this juncture. And the faculties here in the campus, you have residential capacity out here, the hostels in the campus. Faculty is almost 1,500 faculty here and performing well in this place. And in this juncture, when we feel it's a privilege and it's an honor for us to host you all this in this place, and let's have good sessions in this next coming 3 days, and we are here to, our team will definitely support you in all directions. Whatever you need, actually, you can directly contact our team in this place, and we are here to support you in this direction. I thank the chief guest and the guest of honors for being present here and having a nice sessions in this place. Thank you very much.
Thank you, sir. All the candidates definitely will feel that they are studying in KL University and as if they complete the law course 3 years in 3 days. Now I call upon the Chancellor Nichamanan Garu to give his address.
Honorable Sri Justice Prashant Kumar Mishra garu, Honorable Sri Justice Akula Venkata Seshasai garu, and Justice Sitaram Murthy, Chairman AP Human Rights Commission, Vice Chancellor KL University, and Sriram, Advocate General State of AP, and Gantar Ramarao garu, AP Advocate and Chairman Bar Council of Andhra Pradesh. My dear senior advocates, dear students and press. In fact, I was just telling Gantar Ramarao garu, you should have kept only either Vice Chancellor or myself, because this is not really our function, but still I thought that then he said, no, you can spend about 2 minutes, because Honorable Justice is here. I understand he has got some other function. So I thought, and I may not take much of your time, but definitely I am extremely happy. The day Sri Gantar Ramarao garu and Mr. Srinivas, our senior lawyer, AP High Court, they approached me. Instantly I felt very happy, because I feel this is very important. This kind of workshop, you call it workshop or a program or a seminar or whatever you may call, because they are conducting about 13, 14 programs, very important technical programs. I have gone through all these programs. They are extremely good. In fact, I know the importance. I know because we at KL University conduct these kind of specialized workshops and programs very frequently. All our seminar halls are always jam-packed and jam-booked, because we give a lot of importance for the practicality, because honorable judges are coming and giving, and very senior lawyers, senior advocates are coming and giving these kind of the material to you. I mean, it is not possible. Maybe for the judges, the government is conducting a lot of training programs, but definitely not to the advocates and lawyers like you people. You definitely require this kind of things. So I immediately reacted and I said I will definitely host it. And I am really happy, because by making you learn these kind of technical things, I definitely feel that I am indirectly helping the society. I always feel, very strongly feel, and I believe this, I am maintaining this university belongs to the society, and I am maintaining this university for the sake and for the betterment of the public and society in particular. That is the reason whenever I get a chance, any opportunity, I always welcome these kind of things. That's what I told my people, my department, my law department, all my deans and everybody. You take this very seriously, like our own function, and you have to conduct it very well. So I think I am really happy, and because in this, along with this technical sessions, if required, I feel and I advise even the Ramarao garu to include this communication skills workshop also, if required, 1 or 2 sessions, because you know very well, communication is very important. Suppose you want to go to the court, before the judge, if you are presenting something, he should be able to understand like what you are trying to say. It is not only the language, it is English language is required. Even if language is not there in lower courts, maybe you can say sometimes in Telugu and all, I don't exactly. But definitely, it is not only the language, it is the communication. Communication is definitely a different parameter, which you should know your body language, your expression, the agony your client is facing. You should be able to, communicate it to the judge. Then only his reaction will be there. Definitely, there will be a lot of his reaction, if you express it properly, they'll be listening. I think we should conduct that kind of things. And if we, in the sessions, if it's not there, definitely we'll offer from KL University. We have very good team of people. We give very importance along with our technical subjects. We always teach these communication skills and all kinds of skills, behavioral skills, a lot of other things like our VC was mentioning. We concentrate on 360 degrees approach. See, my aim is to prepare a good citizen of this country who can live on his own. That is my target. That is how I train my students. That is my target. People talk of this placement and all that. That is only a byproduct. That is not my real aim. My real aim is I want to prepare a citizen of good citizen with a good heart who can be a part of this society. He can't be a different man because we are born here, we are living here. So we are, whatever we have here, we got everything from this society only. So we have to give back something to society. That is the reason I send my students 15 days compulsory things to the villages. We have a smart village program. And I send my faculty, my students, we made it mandatory. If they go there and they have to stay there, they have to go and work in the villages. I want my students to see the village people, how they are facing problems, and then we need to work for the society and for the upliftment of our villages and our poor people. Even I advise even the lawyers or even the advocates or anybody, we have to keep in mind, along with our profession, you have to keep in mind the society, the poor people, a common people. If they get justice, more than food they are feeling for the justice. I definitely realize your role very much important in the society. So I want all of you to work with good ethics and also with the social the societal mindset, and also work very hard with passion. If you work with passion, money will definitely come. Don't work for money. I always tell my students or my faculty members many times, don't work for the money I am giving you. You work with passion. Money will automatically come. That's what I tell. Anyway, I don't want to take much time. I just wish this a grand success, this 3-day program. And I wish all of you go back with a good knowledge, technical knowledge, legal knowledge and all that. Thank you. Thank you very much.
Thank you, sir. This theatre is under renovation. Sometime back when I came to this campus, it is not available. Only seminar hall they agreed to give us. But because of the initiative taken by the Honorable Chancellor, by deploying extra workforce, they have completed and handed over to us. We are thankful to you, sir, and for your message. That in the beginning itself, you gave a message, the role of the lawyers, apart from the professional duties toward the society also. Thank you very much, sir. I request Sri Justice Sheshashayar to give his message on this occasion.
First of all, let me wish you a happy Mother's Day. President of this event and respected Chairman, Bar Council of Andhra Pradesh, Sri Ganta Ramarao garu, Captain of Andhra Pradesh State Judiciary, our guide, philosopher, Honorable Chief Justice Sri Prasant Kumar Mishra ji, other respected dignitaries and members of legal fraternity. Good morning, one and all. All of you know, the only thing that multiplies on sharing is the knowledge. Obviously, keeping in view the said aspect, the AP Bar Council is holding and organizing this type of orientation programs very frequently and periodically. For this great service, certainly AP Bar Council is entitled for lots and lots of appreciation. In what manner? In what manner, sir? Unlike other professions, right from the inception, beginning, members of this noble profession are called learned. Why? Why they are called learned, unlike other professions? That the respect the society shows towards the advocates, sir. We should feel proud of the same. Therefore, my appeal to all the learned advocates is, let us live up to those expectations. In order to be so, we should have knowledge in abundance in law. For APV, the same. Undoubtedly, this kind of programs would be of immense help. I request all of you, all the learned participants, to make use of this wonderful event and get benefited. Finally, I thank one and all, and also the management of this prestigious institution for affording this good opportunity to me to participate in this very good program. Thank you. Thank you very much. Jai Hind, Jai Andhra Pradesh.
Thank you, sir. I can say that wherever, whenever we call, my Lordship is already available for the Bar Council, and we never missed him on any occasion. We are thankful to you, sir. Now, the Honorable Chief Justice, he was the leader of the bar because he was the chairman of the Bar Council. He by status, he was the leader of the bar because he was the Advocate General before his Lordship was elevated. And therefore, I call upon in all fairness because my Lordship is having insights of the profession from top, from the bottom. So I request his Lordship to give his message for which all of us are waiting.
My esteemed brother, Justice EBCSSI, Chairman of Chancellor of the University, Sri Koniru Satyanarayana, Bar Council Chairman, Sri Ghanta Ramarao, Vice Chancellor Dr. G. Parthasarathy Verma, Justice Sitaram Murthy, Chairman, Human Rights Commission, respected members of the AP Bar Council, my dear lawyer friends, students, faculty of the university, ladies and gentlemen, I am really delighted to be here for the first time in any function of the Bar Council of Andhra Pradesh. Mr. Ghanta Ramarao said that Bar Council was missing me because I was not able to attend because of for some reason or the other. But that is not true. It is the converse which is true, that I was missing the Bar Council. As a lawyer, when I contested the election for the member of the Bar Council in 2002, and I visited the nook and corner of the state and soliciting votes, I traveled across the state and met thousands of lawyers at that time. And that was the occasion when I came across the plight of the lawyers as to how they survive at the professional level. The, the atmosphere and the difficulties, the adverse situations when the lawyers face at the grassroots level, not only at the municipal level, but down below, when there are no municipal courts and you have to attend the revenue courts. There lies the actual difficulty and there lies the heart of the country, there lies the rule of law. In bigger places, in places where High Court is established, people are generally more aware of their legal rights, but in remote places, people are not really aware as to what is their rights are actually and how the rights can be enforced. And therefore, the lawyers at that level, that professional level or even down below, they owe the responsibility and they are the torchbearer for enforcement of law as to how we should take it further. Much has been said, and we all know the role of lawyers in the freedom struggle, not only in this country but throughout the world. Lawyers are backbone of the society in every aspect of life, and it is they who fight for the causes of the common people whenever occasion arises. And it is really a wonderful occasion, and we must thank Mr. Satyanarayana in extending help to the Bar Council in organizing this event. In fact, this event is not only by the Bar Council of Andhra Pradesh, but it is in collaboration with the KL University. It is Brother Ghantarao Ramarao was saying that the boarding facility is all provided by the university. The entire arrangements for this auditorium and next 3 days of the technical sessions, they will all be duly assisted by the university and its faculties and other staff. And that was a very, very kind gesture on the part of Mr. Satyanarayan. I am told this university, established in the year 1918, has around 18,000 students with 3 off-campus institutions in Hyderabad, and we wish that the university will go further and its wings will be spread throughout the country. Coming back to this orientation course, this orientation course for lawyers are much needed. They are need of the hour, because as it is said that what you do in practice in the courts are not taught in law school. There is a very popular perception and popular saying that 90% of the things which you are required to apply inside courts are not taught to you, and 90% of the things which are taught to you in law schools are not really applicable in the courtrooms. So here you will be imparted the training as to how to present your case, and just as Mr. Satyanarayan says, that communication skill is one such most important factor. Unless you are able to communicate properly with the court, and before that not with the court but with the client also, this communication skill is start playing its role at the stage when the litigant approaches the lawyer. And at that time, when you don't properly understand the difficulty of the litigant, you will not able to prepare the case, draft the case well. And if the drafting is not proper, then the presentation in the court is further difficult. So that is how communication, in fact, advocacy is all about communication. Without communication, there can be no advocacy. Maybe sometimes some lawyers are not good in expressing themselves in courtrooms, But there are lawyers who are not good in communicating in courtrooms, but their communicating in writing, in drafting is so good that it too makes up the deficiency. So either way, either you are good in dictating and putting it down on papers, or you are such a good orator in court that you win cases even without proper drafting. In either way, communication is one good part. And in court, it is always said that why communication is important is that in court, what not to say is sometimes more important than what to say. If a judge is very smart, intelligent, then he will pick up your loopholes by using your own submissions. And then you lose a case which you were supposed to win. So what not to say is more important in court than what to say. And what not to say is also part of communication. It is not that communication means only what you want to say. What you don't want to say is also part of communication skill. That is how that communication skill is very important. About more than 500 lawyers from across the states have come. Mr. Ramarao was saying that some more lawyers are likely to join. And really a very, very happy occasion to be amongst lawyers after a long period of time. I have been conducting, I have conducted this orientation courses when I was chairman in the Bar Council. And it's a nostalgic moment for me, going back down the memory line and finding myself amidst lawyers. And I really thank you, Mr. Ganta Ramarao and University and all the members of the Bar Council. And I extend my best wishes to all the lawyers. And whenever I address gathering of the lawyers, I always extend my best wishes to lawyers by saying that may God give you prosperity to purchase new vehicles, new houses, and everything new. Thank you so much.
Thank you, sir. With this orientation program, they will improve their knowledge, change their attitudes, and start buying new vehicles and new houses, sir. Thank you, sir. Now the felicitation of the chief guest by Chancellor Garu. Now the Vice Chancellor Garu will felicitate Justice Shashishri Garu. I request Chidambaram and Subbarao to come onto the dais and felicitate the Chancellor, Sri Satyanarayana Garu. I request Chandrasekhar Reddy Garu and Brahmanand Reddy Garu to come on to the dais and felicitate the Vice Chancellor. I request Chidambaram and Subbarao Garu to felicitate the Chancellor. No, Mangas, Bar Council. Bar Council. Next. ఛాన్స్ ఇయ్యరు అడిగారు వైస్ ఛాన్సలర్. We request Mr. Sundaram to propose our top points for this inaugural session.
On behalf of the Bar Council of Andhra Pradesh and Advocates Fraternity, I offer my sincere thanks to Honorable Chief Justice of High Court of Andhra Pradesh, Prashant Kumar Mishra ji, for spending his Lordship's valuable time and offer his inaugural message. I also extend my sincere thanks to Honorable Sri Justice Akula Venkata Sashai Garu, Judge High Court of Andhra Pradesh, Sri Koneri Satyanarayana Garu, Honorable Chancellor KL University, for their gracious presence on this occasion. I also extend my sincere thanks to Vice Chancellor Dr. Parthasarathi Verma, Head of the Departments of KL University, and all administration staff for excellent arrangements within short time and rendering their services for making the inaugural session a great success. I also thank all the advocates who came from different parts of the state to participate in this program in spite of their busy schedule in their profession. Last but not least, I also extend my sincere thanks to print and electronic media who covered this program. Thank you one and all.
With this, the inaugural session comes to an end. We will take a short break, 10 minutes, and reassemble within 10 minutes so that we can start with the first session. Please have a as quickly as possible, and come back within 10 minutes, please. Thank you. You can have a tea and snacks on first floor, sir. Outside. Please kindly, as soon as possible, you finish and come.
సుబ్బారావు గారి నేమ్ బోర్డు సుబ్బారావు గారి నేమ్ బోర్డు ఎట్లా నువ్వు ఒకళ్ళు రండి నా దగ్గర సార్ నా ఒకసారి అడిగింది అంతే ఇక్కడ పెట్టు దూరం శ్యామగా చాలా తీసుకుంటున్నారు చేసేసాయి కదా చేసేసాయి కదా మిగతా తీసేసి ఇంటిపై కొట్టిస్తున్నాను ఇంటిపై చేసేసాయి కదా అక్కడలో ఉంచు సుబ్బారావు గారు ఒకటి పెట్టుకోండి మిగతా నేమ్ బోర్డు చెప్పండి ఒకటి తీసేసి నేమ్ బోర్డు బోర్డు రెండు బోర్డు షేర్ గారు ఫస్ట్ ఇంకొక దానిలో ఫస్ట్ స్టేషన్ ఒకటి పెట్టాలమ్మా
ఇంకో ఫోల్డర్లో ఫస్ట్ సెషన్ ఒకటి పెట్టాను. ఒకటి ఇస్తే చాలేదు ఫస్ట్ సెషన్. ఇది రాదు. సుబ్బారావు గారు ఒకటి పెట్టు టీ. నేను నీదా నాకు ఎవరలా నువ్వే కాపీ చేసుకున్నావు. నేను వస్తున్నా ఉండు. ఫ్రెష్ వాటర్ పెట్టండి. రెండు పెట్టాను. దాంట్లో వాటర్ పెట్టేది అప్పుడే చిన్న దాంట్లో ఏ4 తీసాను. మొత్తం ఒకటే మొత్తం పెట్టేద్దాం. ఒకసారి మళ్ళీ విడివిడిగా పెట్టడం మొత్తం డే అంతా పెట్టేద్దాం. ఇప్పుడు నా దాంట్లో పెట్టే చూడు, అది ఒక్కటి పెడితే చాలు. మళ్ళీ లేకుండా మళ్ళీ కట్ చేయాలి. ఈ బ్రేక్ లేదన్నావు మళ్ళీ అదే మరి నువ్వు వద్దంటే ఆయన ఛార్జింగ్ చూసుకున్నా ఎక్కడ పెట్టాలి. అక్కడ కూర్చొని మాట్లాడుతున్నా మైక్ పెట్టేసిన మైక్ అక్కడ అవుతా మాట్లాడ ఇన్విటేషన్ కార్డు తీసేసారని అక్కడ పెట్టద్దా రెండు ఉన్నాయా? అది లంచ్ తర్వాత కదమ్మా. కూర్చున్నారు ఉమ్మంటూ ఎప్పుడు ఆయన లంచ్ తర్వాత కదా వచ్చింది. ఇక్కడ ఏదో డిస్కస్ అయిపోయాయి కదా ఇప్పుడు శేషాయి గారికి వాళ్ళు ఇది కోనేరు శిక్షణ తీసా అవసరం లేదు. దానికి అనిపిస్తా అది ఇక్కడ 3 ఉండాలి. ఇంకొకటి నూతల పాటు
పెట్టేయండి లాస్ట్ అదే ఉంది కదా ఉంది ఉంది రెండు పెట్టి ఊడుతుంది చాలు అడిగేద్దాం పవన్ ఆయనకి నేను పిలుస్తాను పవన్ పిలుస్తాను ప్రింట్ ఇవ్వండి ఒకటి అంటే ఎవరు సార్ మేడం పవన్ సార్ని పిలవరా శేషాయి గారు నాన్న ఇట్లా కొంచెం ముందు జరుపుదాం ఇది మేడం ఈ సెషన్ ఇద్దరు మళ్ళీ పిలవాలి.
ఓకే
ఆనరబుల్ శేషాయి గారు సుబ్బారావు కూర్చుంటారు. ఆ రిక్వెస్ట్ ఆనరబుల్ శేషాయి గారు అడ్వకేట్స్ పెట్టారు. ఇదే మన వాళ్ళు ఉన్నారు కదా, లేదు మీ పిలవడం మీ వాళ్ళు ఎంతో యాంకరింగ్ మీదే, యూనివర్సిటీ పీపుల్ ఉంటారు. ఆయన లేకపోతే ఇంకో వాళ్ళు ఎవరు లేరా, లేకపోతే ఆ మేడం పిలుపుతామా? జస్ట్
ఎవరినైనా పిలిపించచ్చు, లేకపోతే స్టూడెంట్స్ తో చేయించు.
స్టూడెంట్స్ చేయించు. వాళ్ళు స్టూడెంట్స్ పిలిపిస్తారు. పిలవడానికి You can read out the names.
Sure, you can invite them on to the dais.
You can invite two people. One is Mr. Isa. I request Honorable I request, I will give the name. PSP Suresh Kumar.
ఇక్కడ రాసేయండి మీరు. pen please. Sorry.
Give sapling to sir. Suresh Kumar garu.
వినోద్ని మ్యామ్, ఆ మ్యామ్ ఇచ్చేసారు, వద్దంట. జేబులో పెట్టుకోండి. So, who is going to accompany?
Accompany no, accompany your people names, students names.
Okay, I request Sri
PSP Suresh Kumar.
PSP
Suresh Kumar.
Suresh
Kumar, Vice President.
Kumar, VP,
Vice President, AP High Court Advocates Association.
AP High Court Advocates Association. Okay.
I will give the name. అడ్వకేట్ సుబ్బారావు గారు. సాహిత్యం లేదు ఇక్కడ,
చెప్తాను, ఫోన్ చేశాను చెప్తాను.
సాహిత్య రిక్వెస్ట్
శ్రీ సాహిత్య శ్రీమతి
సాహిత్య.
Should I call Srimati?
బొకే మా నాన్న సుబ్బారావు గారికి.
I request Srimati Sahitya to present a sapling to Sri Moppal Subbarao.
Yes, sir.
Moppala.
And accompany right to our students.
హ్యాండీగా ఎవరుంటే వాళ్ళు మ్యామ్ పెట్టుకు ఇద్దరిని
దగ్గర ఉండాలి నాన్న ఇప్పుడు.
అదే దట్స్ వాట్ ఐ యామ్ సేయింగ్. మన బయట మన
I request all the committees please be seated. We are going to start the session.
I request all the dignitaries to be seated. We'll be starting the program in a short while. I repeat, I request all the dignitaries to be seated. We'll be starting the program in a short while.
Sure.
Session starting and closing.
Should I say this aspect? Should I say this aspect? This is session, right?
This is session. This one will Subbarao will take this one.
Moppal Subbarao.
Take this one.
So after requesting them, I need to get job. My job is done.
Job is done. I request Subbarao to take this session.
To present a sapling to
After this completed, tell I request Subbarao garu, can you take the present to this session?
Done, sir.
Then Subbarao garu
2. So, can we have a company for both of them?
Yes.
Manish, Janu?
Company.
Attention, please. We have found an ID card that has been lost by Mr. Ajay Sudarshanam. I repeat, we found ID card which is lost by Mr. Ajay Sudarshanam. We request him to come to the dais and collect it. Please collect it from the organizers.
విరోధి మాట్లాడుతున్నారు విరోధి
I request all the dignitaries to please be seated. We are starting the program in a short while. I repeat, I request all the dignitaries to be seated and we will be starting the program in a short while.
ఏంది ఏమవుతుంది లిస్ట్ వెళ్ళిపోతుంది లిస్ట్ అది లాస్ట్ ఈవినింగ్ కొట్టేసి అది రేపు నేను వాళ్ళ ప్రింటింగ్ ఇస్తాను సమ్మర్ నెంబర్ మనకి క్రెడిట్ కార్డు ఇచ్చేసి వాళ్ళ కూడా పేరు రాస్తానని చెప్తాను ఈడీస్ మిస్ చేశాను నానా
ఎలా వెనక్కి ఎవరు నీకు కనిపిస్తుంది జడ్జ్ హైకోర్టు అప్పుడు నాకు చీజ్ వస్తున్నట్టు కనిపిస్తుంది
Dear friends, small request. Just now I observed some of empty cups on the floor. There is a provision made by them for disposal of those cups. Please kindly keep in mind. We will cooperate in the best possible manner. Let us not contribute anything which will make this campus unclean. I told you, best contribution is not to spy, not to do any damage to the serenity and the cleanliness that that is being maintained in this campus. Do your best to maintain the same. Nothing wrong. So by doing that, it will enhance our reputation, our institution reputation, our individual reputation, our professional reputation. Therefore, please kindly take a little care instead of throwing it on the ground. Please deposit that in the appropriate place. Thank you. It's also brought to my notice that still some cell phones are in the ringing mode. If you can switch off, switch off. Otherwise, at least keep them in silent mode so that it will not disturb the program. That is the best way is this, you can discuss with your neighbor any subject because all these days we are spending out of a particular year, 3 days only we are taking out. These 3 days are very crucial for our career. Please understand, you will not get opportunity again. We don't know when it will, this kind of program will be conducted because various factors. 3 years back we planned but could not succeed. So please kindly understand that devote yourself. If any inconvenience there, please kindly go out, attend your calls, and spend some time. You have a cup of tea. Cafeteria, it is always, I was told that 24 hours it is open and you can go any number of cups you want, you have it when you want to relax. But don't disturb your immediate person or don't disturb the tempo of the program. Thank you.
Shut up.
I request dignitaries to be seated.
I request all the dignitaries to be seated for starting the program. I also ask all the dignitaries who are outside to please come into the hall because we are starting the program. I request all the dignitaries to please be seated quickly. We're starting the program. I request the Honorable Sri Justice Akula Venkatesesha Sai Garu, Judge High Court of AP, to come over to the dais and adore the chair. I request Sri Jahannavi Angajala to accompany the Honorable Justice to the dais. I request Sri PSP Suresh Kumar Garu, Vice President of Andhra Pradesh High Court Advocates Association, to present a sapling to Honorable Sri Justice Akula Venkatesesha Sai Garu. I now request Sri Muppala Subbarao Garu, Member, Bar Council of Andhra Pradesh, to come over to the dais and adore the chair. I request Sheikh Samia Sadaf to accompany Sir to the dais. I request Srimati Sahitya Garu to present a sapling to Sri Muppala Subbarao Garu. I now hand over the show to Muppala Subbarao Garu to preside.
Now, the Honorable Justice Devi Shashai Garu deliver his valuable speech on Civil Procedure Code with special reference to disposal of IAS. I request the Honorable Justice, please deliver his speech.
Sorry, Subbarao Garu. This is neither a speech nor a message, sir. It is only a sharing of thoughts, sir. Let us begin this session by offering salutations to two great sons of the soil. One is father of the nation, Sri Mahatma Gandhi ji. Other, Bharat Ratna, Sri B.R. Ambedkar. Father and the author of the Constitution, the great document. In my opinion, this kind of programs are required to be conducted very often so that there can be interaction, not only interaction, but also introspection. which are highly essential for our profession and the system at large. Dear friends, very often we come across in the society, rather in our field, that everything should be done in accordance with the law. Everything should be done in accordance with law. What is meant by law, first of all? We should know. So, what is the meaning of the law? There are so many youngsters here. Would anybody enlighten us? Don't hesitate, sir. As I said in the inaugural session, you are all learned. Not only learning, but also you should be bold also. Yes, Nana, చెప్పమ్మా. నేను అందరూ చూస్తారు. మైక్ ఉందండి అది బెటర్ అది.
Sir, law is nothing but a command of sovereign, as said by Austin.
Austin said so.
Yes.
Law is common sense, one friend says. Another friend says, fool. Law is a ocean. Samudram. Mahasamudram. Anybody else? Law is natural justice according to another friend. Sir, law means and includes rules, regulations, and procedures. Is it defined anywhere, sir? I would like to know. Is it defined anywhere or is it clarified anywhere? Yes, Nana, Chepamma.
Article 13 speaks about what is law. Law is the precedent order.
Article 13 of what?
Indian Constitution.
Indian Constitution. What does it say?
What law includes, sir? Law includes any legislation, bylaw, subordinate legislation, order passed by the competent court. It even gives the precedentially value to the judgments. It can be considered as law.
We would like to know your name.
Myself, Manoj, sir.
Manoj, from which part of the state?
Sir, I am from Amlapuram, sir. I am pursuing BLLB from Damodaran Sanjeevaya National Law University.
Very good. Let us appreciate it. What he said is correct. Article 13, as pointed out by the youngster, takes care of the situation. Another doubt of mine is, can there be a law contrary to the provisions of the Constitution? Not only Damodaran Sanjeevaya, but also other colleges. It can never be contrary to law. Is there any provision under the Constitution which takes care of this situation? Article 13. It specifically mandates that the laws inconsistent with or in derogation to the fundamental rights are void in law. Void. All of you know, laws can be broadly categorized into two. They can be broadly categorized into two. Anybody? ఒక్కసారమ్మా లేదు చెప్పమ్మా. Is it substantial? Substantial లేకపోతే ఇంకే పదం ఏమైనా ఉందా? Yes, substantive. Substantive and procedural laws. Then what is meant by substantive law? Youngsters from the backbenches. Backbenches are always meritorious, sir.
Yes, Master.
Law which creates the rights. Anybody else? Obligations. Yes, sir. Penal law. Liabilities. Substantive law deals with the rights and liabilities of the parties, whereas procedural law prescribes the mechanism and the procedure for enforcement of such rights and liabilities. Then in this scintillating event and on this auspicious occasion, I have been asked to share my thoughts on the topic Civil Procedure Code with special reference to disposal of interlocutory applications. All of you know the Code of Civil Procedure 1908 Code. It regulates the procedure which needs to be adhered to in civil suits. Then, when this CPC was codified, anybody? When this Civil Procedure Code was codified, of course, during the British regime. Emma? When the CPC was codified during British regime. So, codified with effect from 1/1/1909. Of course, all of you know, so far it has undergone a number of amendments. When the last amendments took place, those amendments came into force when?
Economically backward. 105.
When, from what date? 105 amendments, sir. Economically backward. Date from which those provisions came into being. 2002 amendments. When they came into force. Yes, 1st July 2002. You are correct, Amma. Then coming to the sections and the orders under the Code of Civil Procedure. How many sections are there? 150 sections, 52 orders. Why you have stopped at 151, sir? Other sections are also there, so why you are cutting them? 158 sections, as rightly said by one of the brothers. 51 orders. And 51 orders. You are correct, sir. What is the object of these provisions of law under the CPC? The object is enforcement of civil rights. Some important sections are, I don't say other sections are not important. Some important sections are, because I have been allotted only 1 hour by the President of Bar Council, who is our boss. Section 9. Let us start from section 9, sir. Section 9. You are saying something, Ma? Jurisdiction of courts. According to this provision of law, courts of civil jurisdiction are empowered to try all suits of civil nature. There is one exception to this. What is that exception? Case anybody? Any suit of any nature is maintainable, can be instituted before a competent civil court in accordance with this section of law 9. But there is an exception to this. What is that exception? Emma?
Sir, there is an express and implied bar provided in section 9 itself, sir. When there is the law itself says that the civil courts bar to entertain the suit, though it is in the nature of civil, by creating another forum, and that can be treated as express bar. But the law does not say, but there are efficacious remedies elsewhere provided under any other forum that would come under the implied bar, sir.
So unless it is barred by a special law,
yes, sir,
either expressly
or
impliedly,
yes, sir.
Any suit can be filed.
Yes.
Of course, before a competent civil court.
Yes.
Another important section is section 10. Next section.
Res judicata.
What is this section 10 of CPC? It deals with what? Stay of suit.
Stay of suit.
Could anybody enlighten on this, sir? Section 10. Because by abundant caution, I said in the beginning, we are all learned. Don't hesitate. చెప్పండి ఇంగ్లీష్లో చెప్పనవసరం లేదు, తెలుగులోనే చెప్పండి. ఏమా స్టే ఆఫ్ ట్రయల్. సపోజింగ్ 2 suits are there. Further suit. Right. Subsequent suit. Supposing 2 suits are there, involving practically the same subject matters and cause of action also. Parties can ask the which suit? Is it subsequent suit or a prior suit? Supposing subsequent suit is a comprehensive suit, why should they stay?
For the competent jurisdiction court.
So whatever be the consequence of subsequent suit should be stayed according to one of our friends. Provision says so.
The margin is already pending for the another forum. Already another forum.
My doubt is, supposing the second suit is a comprehensive one, what will you do? First suit is merely an injunction suit. Second suit is a suit for declaration also. What will you do? Would you get the second suit stayed or first suit? Or you would ask both the suits to be tried together? Then, what is the object behind this, sir? సార్ అక్కడ ఎవరు మాట్లాడలేదండి, వెనక బెంచ్లో ఎవరు మాట్లాడలేదు. దయచేసి పార్టిసిపేట్ చేయండి, ప్లీజ్ పార్టిసిపేట్. దిస్ ఈజ్ యువర్ ఓరియంటేషన్ ప్రోగ్రామ్. What is the object behind this provision of law? Sir? To prevent conflict of decisions, to avoid multiplicity of litigations. No one can be. Next provision of law takes care of it, Amma. Not this one. So let us enter into 11 now. To protect the court time. Section 11. Deals with the res judicata.
Res judicata.
What is barred under this provision of law? Same parties, same subject matter. Already decided. Ever somebody is saying that. Sir, this is where is the mic? Yes, sir, please, sir. Sir, res judicata means it is a bar of courts. Already decided by the court. Same parties, same subject matter. Already decided by the court. Subsequent case is barred. So, institution of second suit on the same issue. Same issue. Precisely. Correct? Yes, sir. Then what is the object behind this, sir? Please share your thought on this. Is there any object behind this provision of law? So, already decided the case, it should not be decided by another complaint court. Because for every issue, there are several courts are here. So, clients will just like a double jeopardy. Yes, sir. Yes, sir. So, this safeguards litigant public, yes, sir, from the onslaught of frivolous and vexatious litigations. Yeah, and another thing is, this gives finality to the litigation. Then all of you know, sections 15 to 20 tell about the place of institution of the suits, jurisdictions. 33 deals with the judgment and decrees. Supposing you are aggrieved by a decree passed by a trial court, what should we do? Appeal. Execution. We prefer appeal. Under what provision of law appeal suit?
96(2). There's 96 of CPC.
Substantive provision is?
That's 96, section 96.
96, sir. Procedure?
Order 41.
Amma? Order 41 deals with that. Takes care of the procedure. All of you know, first appeal is a right of appeal. It's a right of appeal, first appeal. Appeal shall lie. That's what the provision says, 96. But not the second appeal. Second appeals are filed under
section 142 of order 42.
Section 100 of the Code of Civil Procedure. What is the difference between first appeal and the second appeal is another issue. What is the difference between these two? Is there any subtle distinction between these two? Or against any decree passed by the appellate court, first appellate court, is assailable before the second appellate court?
May I answer it, Miller?
What is meant by substantial question of law? On question of law, first appeal lies. When you intend to file second appeal, there must be substantial question of law. What is meant by this?
Not decided by any other court.
Which is not decided by the earlier by the High Court or Supreme Court of the country. That there is no precedent to that extent of the substantial question of law.
But to the extent my knowledge goes, a question of law, if somebody is saying something. Enama? Mic don't work, amma? Oksar mic don't amma working. Let him tell that. Oksar mic only.
Sir, for the benefit of enlarged society.
1 minute, sir. Chepnana. I want the distinction between question of law and substantial question of law.
There is an apparent error in the judgment and a new material evidence is discovered later.
That is called substantial question of law, according to you. I will deal with that also, don't worry. But it is covered with some other provision of law. A question of law, yes, sir, you are saying something, sir.
Sir, definitely it can be used for larger society. So for that purpose, second appeal may be preferred. That will be the condition also, if it is useful for larger society.
So condition precedent for maintaining a second appeal is the existence of substantial question of law, according to you. Our doubt is what is meant by substantial question of law. It is not merely a question of law. It is not merely a question of law. Question of law may be available to you for first appeals, appellate suits. Substantial question of law, a question of law which substantially affects adjudication of the issues is called substantial question of law. In order to maintain second appeal, first of all, you should show the existence of the substantial question of law.
And also, sir.
Yes, sir, you are saying.
And also it should be beneficial to larger society.
Beneficial to
public importance.
Public importance, right?
One way.
So for first appeal, there is no public importance, sir.
So more than that.
More than that.
Yes.
Excellent. Yes. Sir, another issue is by way of 2002 amendments to CPC, under certain circumstances, second appeals are barred. Second appeals are barred. What is the contingency? By insertion of section 100A of CPC, sir. Wherever the value does not exceed 25,000, second appeal is not maintainable. Is it applicable to suits of all nature? Somebody said no. What is yes? What is yes, sir? Amma? The only exception is money suits. In money suits, wherever the value does not exceed 25,000, second appeal is barred. And for some time, some experiments were conducted before the Composite High Court of Andhra Pradesh in this regard. One of them was, we used to file CRPs. Second appeal is barred. Why not CRP under 227? Our advocates fraternity used to file them. Only appeal is barred, that's all, not the revision. But the Composite High Court said, when appeal is barred, you can't maintain the revision. Ultimately, it is set at naught. So, another important provision of law under the CPC is section 151, Tarak Mantram.
Power of the court, sir.
Inherent power of the court. Inherent power of the court. So, this is vacant to which provision of law under CRPC, sir?
151 section.
151 CPC. 482. This provision confers inherent jurisdiction on the courts for the ends of justice. Is it always available? Is it discretion of the court? It is a discretion of the court for the ends of justice. Is it discretion of the court only? To prevent abuse of process of the court. Abuse. What are the other objects? Anybody?
If we don't have any particular provision, then we can give an order.
In the absence of any other provision of law, we can invoke the provisions of section 151 according to one of our sisters. Yes, anybody? Yes. When there is a specific provision under this CPC, you can't invoke 151. It is set in law. Supposing against an order passed by trial court, appeal lies. I came across one case. An application was filed to set aside an order setting a party ex parte. Then, to set aside that order, an application under section 151 was filed. Is it maintainable? Why? So that is the distinction, sir. Apart from 158 sections, all of you know, there are 51 orders which ultimately deal with the procedural law. Since we are dealing with the interlocutory applications specifically today, let us concentrate on them. If we treat the suit as a tree, ఒక చెట్ల మనం భావిస్తే CPCని, or if you treat the suit as a tree, its branches are interlocutory applications. Before going further, we should know what exactly the object of these interlocutory applications. What is the object of these interlocutory applications? IAs. Why should we file IAs? To give interim relief to the party. Then, Inka.
For speedy redressal of the dispute.
Why suit is pending?
Damages.
Yes, sir. Interlocutory enter interim relief to prevent damages. All these are correct, sir. The object of IAS is, and the orders passed through thereon, is the preservation of the rights of the parties and the property pending final adjudication of the issues in the suit. Then, I would like to place only certain important IAs which we come across very often in our day-to-day adjudicatory process. This doesn't mean that other applications are not important. They are equally important. First application is, let us start from order 1. First application is order 1 rule 10. It deals with what?
Written of the plaint.
Yes, somebody is saying. Let it be clear.
It deals with the written of the plaint.
What mic on? Brother mic on. Third row, middle. Adding and deleting the parties. Adding and deleting the parties. Deletion of the parties. What is the conditional precedent for invoking this provision of law?
Necessary and proper parties.
Necessary and proper and necessary parties should alone be pleaded. Another contingency is presence of such individuals or the parties should be necessary for complete adjudication of and settlement of various issues. Then what is the object behind this? Object of order 1 rule 10. Please also we avoid multiplicity of litigation. I request you to make a note of these judgments, leading judgments. AR 1999 Supreme Court, AR 1999 Supreme Court, 976. Parties names Savitri Devi versus District Judge. Savitri Devi versus District Judge. Another judgment is AR 1968 Madras, AR 1968 Madras 287. Then AR 2010 Supreme Court, AR 2010 Supreme Court 3109. Then our High Court judgment 2012 third volume, 2012 third volume ALD 128, so also 320. Another important aspect is in a suit for specific performance of contract of sale, whether a third party can be implicated. It's a crucial issue. Kindly participate, sir. In a suit for specific performance of agreement of sale, contract of sale, whether a third party to the document can be implicated or is entitled to come on record. Raman garu saying something. I will come to you, Amma. Raman చెప్పండి అది తీసుకోండి మైక్ తీసుకోండి.
Sir, when third party is
please.
After executing document, subsequently, if that property is alienated to another party, if his interest is involved in it, Milad, he can.
Why should he come on record? He can maintain a independent suit for declaration of title and injunction. Why should he come on record in this suit? Let them fight. He can leave them.
Independent suits may result in multiple judgments and may have conflict each other.
But the Honorable Supreme Court said otherwise. A person who claims right independent of the rights of the parties to the agreement, they can't come on record. That's what the Honorable Supreme Court said. You may be correct from your point of view, because in order to protect his interest or her interest, normally she or he will be anxious to come on record. Yes, anybody?
When he is the
yes, Amma, you are saying something.
When third party is the beneficiary of the
where is the mic?
Yes.
Yes, Amma, please.
When the third party is the beneficiary of the suits, when his rights are violated, he can be added.
What is the provision of law which deals with that? Is there any provision of law? I will tell you one example. In one case, a peculiar situation cropped up. చాలా విచిత్రమైన పరిస్థితులు అండి అందులో. Parties implicated certain individuals, but they remained ex parte. It is purchased by another individual. What should he do? As rightly said by Raman, in a suit for specific performance of contract of sale, the defendant, supposing remains ex parte. He doesn't contest the suit at all because he already sold it to somebody else. That third party wants to come on record. What is the fate of this individual? Should he be allowed to come on record or he should not be? Yes, somebody should be there. That's what I wrote. Then another peculiar situation cropped up in one case. Parties implicate the learned presiding officer also at appellate stage, who rendered the judgment in the suit. In appellate stage, the learned presiding officer, judge అని కూడా ఇంప్లీట్ చేశారండి పార్టీగా. పెక్యులర్ సిచ్యువేషన్స్ వస్తాయండి ఇవన్నీ కూడా. Should he be permitted to implead in such a manner? No. That's what the Honorable Supreme Court said. And Supreme Court deprecated such course of action, awarded exorbitant costs. This judgment, what I told you, 1999, 2 SCC 577. Already told you. 1999, second volume, Supreme Court cases 577. Savitribai versus District Judge Gorakhpur, UP. So this is broadly about Order 1 Rule 10. Next application, important application, is appointment of commissioners. Appointment of commissioners. What is the substantive provision of law?
Section 76.
What you said initially is correct, sir. Initially you said 75. That is correct. 75. And order 26. For what purposes commissioners can be appointed or can be sought for?
To fix the meets and bounds of the properties.
To measure
the boundaries of the property.
Boundaries of the properties.
To record the evidence of the
recording the evidence. To sell the property.
To preserve the property for the
preserve the property. Partition the property.
Partition, yes.
Division the property.
He can sell it. He can also, for the purpose of sale, also he can be.
For examining witnesses. Then to make local inspection, to examine accounts, to make partition, to hold scientific, technical or expert investigation, and to conduct sale of property. You may get so many doubts while dealing with this sort of applications. Can a commissioner be appointed for collection of evidence? Why? Why is the question? Why it cannot be appointed? It is a settled law. A commissioner cannot be appointed for collection of evidence. It is a settled law. Why? Parties independent of the commissioner. వారికి మైక్ ఇవ్వండి ఒకసారి.
The parties.
What's your good name, Mama?
Salim.
Salim from which bar? Narsarawpet. ఒకసారి చెప్పండి అమ్మా.
Parties independently, by adducing their evidence, they have to prove their case, but not depend on the commissioner's report. So the commission cannot be appointed for collecting of the evidence.
నా డౌట్ ఏంటంటేనండి, commissioner is an extended arm of the court.
Yes.
Isn't it?
Yes.
To know the ground realities, commissioners are appointed.
Yes.
Why not for collection of evidence?
It is not the duty.
Some brother is saying. Sir.
It is not duty of the court to collect the evidences.
It is not the duty of the court to collect the evidence.
Yes.
It is for the parties.
Yes. The burden is on the party to prove their case.
Good, excellent, sir. So these judgments, please make note of. 2008 first volume, Andhra Legal Decisions, 461, 2006 first volume, Andhra Legal Decisions, 372, 2010 fifth volume, ALD 83, 2011 second volume, ALD 472. Another issue is whether court can appoint a commissioner. Sumoto. Yes. Is it permissible to appoint a commissioner sumoto by the court? Under what circumstances? Under what circumstances a commissioner can be appointed sumoto by the court?
In order to come to a right conclusion,
it is for the parties to prove it. Why should the court bear the responsibility of collecting the evidence? Please make a note of this. 2006 first volume Andhra Law Times cannot be. That's what the court said. 2006 180 146. Very often we come across this situation also. Whether a second commissioner can be appointed. Can it be appointed? Whether a second commissioner be appointed. Yes, sir? Sir, sorry, sir, give mic to him. Sir, let him say. Yes, sir, please say that. Whatever you want to say.
Only if the first warrant was not executed.
Only when?
The first warrant, the commissioner could not execute the warrant. Then the court can appoint the commissioner.
In the absence of submission of the first commissioner's report, a second commissioner for the same purpose can be appointed. Supposing
Commissioner appointed and then commissioner attendance in report collecting and report submission time and then objections mentioned in the parties, pleaders, counsels, objections raised above, it inca properly correctness in the commissioner report and then second commissioner appointed.
So according to you, after the consideration of the objections by the other side, who is agreed by the commission's report, the second commissioner can be appointed. Right. Anybody? Yes, sir. Somebody is saying valuable answer. Pertinent answer. Yes, sir. So according to you, unless the first commissioner's report is set aside and scrapped, second commissioner cannot be appointed. Yes, you are correct, sir. 2017 fifth volume, Andhra Legal Decisions, 1-3, page number 1-3. Another doubt of mine is, in a simple suit for injunction, can we appoint a commissioner? In a simple suit for injunction, that's all, no other relief. Whether commissioner can be appointed. Yes, sir. Therefore, question is, in a simple suit for injunction, plaintiff is not asking for any other relief. Sir, you are saying, sir. In a simple suit for injunction, but there is no bar as such. When there is a dispute as regards identity, then only it can be done. Under normal circumstances, this is not permissible, sir. The relevant judgment is, rather judgments are 2013 second volume 86, 2013 second volume ALD 86, not 36, 86, and 2015 fifth volume ALD 460. Last but not least, under this provision of law is, in execution, whether commissioner can be appointed. In EP, whether commissioner can be appointed. What is the provision of law which deals with that? 21 deals with the execution of law. The relevant provision is Rule 18A, which enables the court to appoint a commissioner. 18A. So this is about appointment of commissioners. Next one is very crucial one, are the 38 Rule 5. Attachment before judgment. You are correct. Then what is the object behind this? Is another issue. What is the object behind are the 38 Rule 5? Is there any special object behind this? Yes, sir.
The party should not transfer that property, prevent the transfer.
Prevent the transfers. Amma? Fraudulent transfers. Sir, you are saying something, sir. Why? Subjudice provision is there that takes care of the situation. Why 38.5? The object is, as rightly said by you, is to prevent any attempt on the part of the defendant to defeat the realization in terms of a decree that is likely to be passed in favor of the plaintiff. That is the object behind that. Of course, this remedy is very harsh, all of you know. Very, very harsh. Attacking one's property. Therefore, strict adherence to the provisions of law is mandatory. While invoking this provision of law, strict adherence is required. You may also get a doubt whether the court, civil court, has power and jurisdiction to attack a property situated outside its jurisdiction. Can be done, sir?
Yes.
130?
137.
కొంచెం దగ్గర రండి
136.
Right, sir. Here comes, sir. 136, which says such attachment order is required to be sent to the district court within whose jurisdiction such property is situated for execution.
One submission. Sir, 136 and 46 difference between the 136 and 46 opposite. Maybe, sir.
Yes, sir. Come to that. The relevant provision is AR 1961. Note down this, sir. AR 1961 AP Division Bench, sir. This page number is somewhat forgotten. 96 4 ALD 1137, sir. Then you may also entertain a doubt. When the property is attached to pending suit, whether there is any necessity to get it attached after the decree during execution. That attachment continues or it ceases to exist. Yes, sir. Somebody is saying something, sir. Not that, sir. Issue is when the property is attached to pending suit, suit is ultimately decreed. In execution, you want to bring the property to sale. Is it necessary to attach the property once again? No. What is the rule which takes care of the situation? Yes, sir? Sir, mic only. Please give mic to him. Because these are crucial aspects, so therefore everybody should know.
RA 21, Rule 64 to 66. Directly approach the Honorable Court for by way of it.
64 to 66 deals with the sale. You are correct, sir. You are exactly correct. You are correct to that extent. There is another provision of law, Order 38, Rule 11, not necessary. Coming to the issue raised by one of our friends here from right side. Supposing there is an attachment order. Supposing there is an attachment order. Suit is dismissed for default. That's what we are saying. Suit is dismissed for default. Application for restoration of suit is filed. That is also allowed. What is the situation after that? Whether issue is whether the order of attachment automatically gets revived or not. So somebody is saying, yes, it automatically gets revived. Anybody, sir? Anybody from this? IA cannot be restored? IA cannot be restored, sir. Right, sir. IA cannot be restored. You should file a separate application for restoration. So there is no automatic restoration of the earlier order. Yes. What is the relevant rule? Let us see. Order 38. Order 38. Rule 11. Capital A. 2. And relevant judgment is AR 2003 Karnataka 128. Sir, I have another doubt, sir. Order 38 Rule 5, this procedure is applicable to summary suits. Order 37 suits. చేయడానికి లేదండి చేయొచ్చు చేయొచ్చండి చేయడానికి లేదండి ప్రోసెస్ ఉందా సార్ ఎక్కడైనా సమ్మరీ ట్రయల్స్ స్పీడీ ట్రయల్స్ సార్ సమ్మరీ ట్రయల్స్ ఆర్ స్పీడీ ట్రయల్స్ బట్ ది ఇష్యూ ఈజ్ డిఫరెంట్ సార్ ఇష్యూ ఈజ్ whether these provisions can be made applicable to those suits or not. No, sir. Which provision bars them, sir? Yes, sir. Anybody? Come on. 38:12. Yes, it is applicable. That's what the court said is applicable. There is no bar, as rightly said by you. So, next important provision of law may be important to all of you. Order 39. Order 39 of CPC. This deals with what? Circumstances, Article 38 deals with, as rightly said by you, injunctions, interim injunctions. All of you know, for grant of injunction, yes, Amma? You are saying something, Amma? Mic తీసుకోండి. Somebody is saying.
Injunction.
Perpetual injunction, 39.
Yes.
Order 39, Amma. Temporary injunction. Temporary injunction, Amma. So for grant of injunctions, the person applying for must show, three ingredients. What are they? Prima facie case, balance of convenience, irreparable loss. Supposing, yes sir, you are saying something, sir. Somebody is saying conduct. I must stop it. Supposing an application is filed under Order 39 rules 1 and 2. Application వేశారు అనుకుందాం. Injunction is granted or refused. Then what is the remedy available? Why not revision under 227? Yes, sir. CMA. CMA under Order 43 are correct. I have one doubt. Supposing an injunction application is filed. Court grants neither injunction nor denial. Status quo granted అనుకున్నాం కాసేపు. స్టేటస్ కో ఇచ్చారమ్మా. ఇంజక్షన్ అప్లికేషన్ చేస్తే స్టేటస్ కో ఇచ్చారు. సాధారణ మనం చూస్తూ ఉంటాం రోజు. డైలీ స్టేటస్ కో ఆర్డర్స్ మనం చూస్తూ ఉంటాం. Somebody saying something. Easy way or easy method? To satisfy both self-security and ప్రకారం అలా కాదు సార్. ఇప్పుడు స్టేటస్ కో ఇచ్చేసాం అనుకోండి, మరి క్రిమినల్ కేసు దారి తీయలేదు. అవునండి, పాయింట్ అది కదండి. స్టేటస్ కో ఇచ్చారండి. ఇట్ ఈస్ నైదర్ ఇంజంక్షన్ nor an injunction is refused. It's only status quo granted. Even then appeal lies or only revision lies under 227. Revision lies. Yes sir. Revision lies or appeal lies, sir? Revision lies. Since it is a status quo order, revision only lies. But the yes, Amma, you are saying, sir. Yes, you are on point, Amma. Yes. Allowing different, denial is different. He is neither denied nor allowed. As said by Chairman Secretary. Majority of them are saying only reason lies. Hey, democracy, sir. We should honor the democracy. Respect the democracy. Yes, what sister said is correct. Even if it is the status quo order, provision of law says 43 says any order passed on application filed under Order 39 Rule 2, 1 and 2 is appealable. Therefore, appeal alone lies. Then supposing an order of injunction is violated, is flouted, disobeyed completely, what is the remedy? Would you know the provisions of the Contempt of Courts Act? Sir, you mic on, sir. చెప్పండి, కూర్చొని చెప్పారు. కూర్చొని చెప్పండి.
2132
20.
Violation of injunction orders.
Yes. Yes, anybody? 2A అంటే దేనికి 2A? 39? 2A, correct. What is the procedure? Supposing an application is filed under that provision of law, how to deal with that? Amma? By way of attachment of property and arrest not exceeding 3 months. That is the maximum punishment which can be given. AR 1998, Rajasthan 115. Then so far injunctions are concerned, whether ex parte injunction can be granted against government or its instrumentalities. Whether ex parte injunction can be granted against the government. No, sir. Sir, please supply the mic, sir. It is important provision of law.
Dispensary section 80 notice, sir. Thereafter, court may grant injunction against it.
So, by dispensing with the service of notice, court can grant ex parte injunction also?
Granted against government.
No.
పర్లేదు చెప్పండి సార్, ఏం పర్వాలేదు చెప్పండి, నెమ్మది చెప్పండి, ఏం పర్లేదు. Issue is whether an ex parte injunction can be granted against the government. Why government stands on somewhere a different footing, pedestal? 80 clause 2, sir. 80 clause 2, sir. 2017, 5th volume, ANDHRA Legal Decisions 174. So next issue is there any time limit for disposal of injunction application if injunction is granted without notice? Under what provision of law? Rule 3? Yes, you are correct. Somebody is saying 3. Mike చెప్తాండి.
Order 39, Rule 3A, sir.
Yes, you are correct. Supposing interim injunction is granted, same situation, suit is dismissed for default. With the restoration of the suit and an application filed by the aggrieved, whether injunction gets revived automatically or not. It revives, sir. వామపక్షాలు ఒప్పుకోవట్లేదండి. An independent order needs to be passed. Please make a note of it, sir. It doesn't get 2004 6th volume, 2004 6th volume, Supreme Court cases 398. Yes, sir, Supreme Court cases, sir. Page number is 398, sir. Last but not least, another important provision of law is Order 40, Rule 1. Appointment of receivers, sir. What is the object behind this provision of law? Custody the property from whom? Custodia legis. We would like to be enlightened by that, sir. What do you mean by custodia legis? Enama? He is the custodian, undoubtedly custodian of property. He is an officer of the court. Kadandi? Then there is one leading case on this, sir. అది ఒక రకంగా భగవద్గీత అని చెప్పుకోవచ్చు. అది AR 1955 Madras 430. Madras High Court laid down certain principles, rather 5 principles, that is popularly called not for Venkatesh. Anybody? Barring him, sir. You are correct. అండి ఏదో అంటున్నారు సార్.
కాన్స్టిట్యూషన్ ఆఫ్ 40 అండి.
కాన్స్టిట్యూషన్ ఆఫ్
40
అది కాదండి. మద్రాస్ హైకోర్ట్ laid down certain principles of law. Under what circumstances a receiver can be appointed, because it is a harsh provision. Taking away somebody else's property from his custody is a harsh one. కదండి, ఇంకో ప్రాపర్టీ తీసేసుకోవడం అనేది హార్ష్ రెమెడీ కాబట్టి 5 principles were laid down by the Honorable Madras High Court. పంచసూత్ర ప్రణాళిక పంచ అంటే 5 కదండి. పంచసూత్ర సార్. You are correct, sir. Pancha Sadachar. They still hold good. That is the leading case, sir. Everybody should read that. 1955. Whenever an application comes up under this provision of law, AR 1955 Madras 430, sir. Recently, I am traveling beyond the time, it seems. Another 2 minutes, I will complete it. I have also to go. You may also get another doubt. Whether court can appoint receivers sooner to, because it is the harshest of the remedies. Please make a note of this, sir. 2009th volume SCC 190. Earlier view was different, sir. That is also there. AR 1987, Supreme Court 371. Whether this remedy is exclusively available to the plaintiff or defendant can also avail this remedy is another issue. Since the suit is instituted by one party, other party cannot file application. That was the objection taken in one of the cases. Is it available to the defendant also? Yes, sir. Available to defendant also, sir. That is, the judgment is AR 2003, Calcutta 178. Then ultimate question is, who should be appointed as receiver? Who should be appointed as receiver? Emma? Independent. A person who doesn't have any interest in the property. An independent, impartial, and totally disinterested person should alone be appointed. Relevant judgment is AR 2001 Supreme Court 1361. AR 2001 Supreme Court 1361. I would also request you to make note of these 3 judgments also. AR 1997 Supreme Court 164 and 173. 164 and 173. Then 1994 6th volume Supreme Court cases 545. Then AR 1962 Supreme Court 21. AR 1962 Supreme Court 21. So this is broadly about certain important interlocutory applications. And for affording this opportunity, I thank the chairman of the Bar Council, Sri Ganta Ramarao Garu, and his team. And I would like to conclude this with the great words of the great saint of our country, Vivekananda. He said, I quote, లక్ష్యం కోసం అలుపెరుగక శ్రమిస్తుంటే నేడు కాకపోయినా రేపైనా విజయం సాధ్యమవుతుంది. థ్యాంక్ యూ వన్ అండ్ ఆల్.
Thank you, my lord. You deliver the valuable address and interaction on the subject with the advocates. Now, the Chairman Bar Council of Andhra Pradesh to give a memento to the Honorable Justice A.V. Shashai Garu.
Thank you, sir. The first section, for launching the first session very successfully, involving all the participants. Same spirit you shall be there. Maybe it is hectic. I promise you, we will promise you that you will be relaxed after serious sessions. Two announcements. One is immediately now you can have lunch. Boys hostel, dining hall, finish it, have a not sumptuous, sufficient. Don't go to sleep mode because you will miss. You will miss important because lunch you can have another day, but this you cannot have another day. So another announcement is after completion of the sessions today, a facility is available here. They will collect blood samples from all of you, and they will be able to give report next day. If possible, we will also that will be analyzed by the medical practitioners, and advice will be given to you. So please avail that opportunity. After completion of the serious sessions, that facility will be available outside the auditorium. Please finish your lunch quickly and come back.
Like medical policy does help us.
And another announcement also, medical policy was launched recently. Any doubt, any query, any help to have your policy, that help desk is available. Thank you.
Friends, evening after this session, Jayaraju cultural program is there, and also some other cultural programs, songs and dances are there. Evening after completing of this session, from 7 onwards.
members to part. Shiva, well numbers to part.
Ladies and gentlemen, the lunch facility is in the Himalayan Boys Hostel, right back of the R&D Theatre. So please proceed towards the Himalayan Boys Hostel, right back of this building. Thank you.
నెక్స్ట్ ఇది కూడా తీసి పెట్టాను. ప్రొఫెసర్ అరవింద్ నోబెల్ పార్టీ కూడా తీసి పెట్టాను. నేమ్ బోర్డు ప్రొఫెసర్ అది కూడా తీసి పెట్టు. రెండు కలిపి ఒకటే సెషన్ కొట్టేస్తాను మీకు. కదా మనం కూడా వెళ్దాం. ఈ సెషన్ తీసుకున్నావా? అది ఇంకో ఫోల్డర్లో పెట్టు. సార్ వాళ్ళు పక్కన ఉంటారు కదా, కూర్చొని ఆ ఫోల్డర్ పెట్టు. నాకు తెలిసిన వీళ్ళున్నారు, చంద్రశేఖర్ రెడ్డి గారిని కూర్చోబెడతారు. ఆ నేమ్ బోర్డు తీసి పెడతారు. ఎవరు ఉన్నారు? శేఖర్ గారు, చంద్రశేఖర్ రెడ్డి గారు. చిదంబరం గారు సార్, చిదంబరం సార్
చేద్దాం. అదే సురేష్ కుమార్ గారు, సురేష్ కుమార్ గారు వద్దు, వాళ్ళు తిట్టుకుంటారు. ఎవరున్నారు ఇక్కడ మన దగ్గర? ఇంకా ఉంటారా? సార్ వెళ్ళిపోయారు.
రన్ చేయడం ప్రోగ్రామ్
అదేలే ఇప్పుడు పైకి వెళ్ళిపోతానులేండి మీరు పై తర్వాత చెప్పా ప్రోగ్రామ్ అలా అదే అడుగుతున్నారు
అందులో లైవ్ ఇవ్వచ్చు అలా కట్ చేద్దాం అది లైవ్ అసలు కల్చరల్ ప్రోగ్రామ్స్
ఏదైనా సార్ వీడియోగ్రాఫర్ అంటే వీళ్ళు కొందరు వేరే వాళ్ళ అందులో మంచి రోజు ఉంటుంది బయట
ఓకే హాయ్ గారు
Good afternoon. I hope that you had a comfortable lunch. Before starting the next session, for convenience sake, please kindly raise your hands. We have no transport facility. Would you like to wait till the end of the programs, including cultural program? If some persons wanted to go after these sessions,
వాళ్ళ నైట్ ఉంటున్నావు
one bus will be arranged immediately after these sessions. And after cultural program, another bus will be arranged. If all of you, if there are sufficient persons only, then we will request them. Otherwise, we will be wasting the fuel. Please kindly, any difficulty like that. And another aspect is, Ebenezer number during night time, because any problem you may encounter, any problem for that matter, one devoted person will be available in the campus. Please note down the number today. One Ebenezer, 99, please note down, 9949739413. It is Ebenezer. Second is Vinod Kumar. Another number 831-7680-863. These two numbers today they will be available even midnight. Any inconvenience to any person, you can contact them, and without any hesitation, you can contact them and ask their help. They will be available.
పేర్లు వచ్చినది ఫోన్ చేసేసి చెప్పండి.
And residents who are there, please kindly wake up early. There is a facility of yoga, and yoga teacher may arrive within short period after this session or so. He will give you what are the requirements, what is the place, and then take the have the benefit of yoga in the morning. And another announcement is, though scheduled time is 10:30, we will utilize 9:30 to 10:30 for other purposes. Some senior advocates come. I wanted to say that 0 hour, because no topic. You may have so many in your minds doubts about the profession or a subject which is not included in the schedule, whatever may be relating to the relevant to the profession, you can interact with them. And I am requesting Justice Kodandram also to be there tomorrow in that session, because he is a senior counsel having a roaring practice, and then entered the judiciary and came back to the profession. So I hope that he will not say no. Tomorrow he also may be available in the jury hour to clarify any doubt respect of our day-to-day professional requirements, life, whatever you say. సీతారామూర్తి గారు అక్కడ ఎవరున్నారు మన గెస్ట్ హౌస్ చంద్రశేఖర్ రెడ్డి గారికి ఫోన్ చేసి తీసుకోండి. Now the next session. Ready? ఎవరు
Good afternoon, everyone. Meanwhile, I request all the respected bar members to settle down and have a comfortable seat. And if you have any queries or doubts, please reach out to us. Our volunteers would help you. Now, I take this opportunity to invite the guests to the dais. I request the Honorable Sri Justice Seetarama Murthy Sir, the former Judge, High Court of Andhra Pradesh and Chairman Andhra Pradesh Human Rights Commission, to come over the dais and adore the chair. Please, sir. I request Ushashri to accompany the Honorable Justice to the dais. Now I request Shri Kavishri to present the sapling to the Honorable Shri Justice Seetarama Murthy Guru. Thank you so much, sir, for being here with us. Now I request Shri Brahmananda Reddy Guru to come over the dais and adore the chair. At the same time, I request Aushul to present a sapling to the sir. Thank you so much, sir, for being here with us. Now I request Honorable Justice Seetarama Murthy, sir, to deliver his valuable address. Please, sir.
Sabhaya Namaha. It's my distinct pleasure to be with all of you and share my humble thoughts on the assigned topic. Today is a day where we are all expected to pay respects to parents, particularly respected mothers. Whenever I come to address a big gathering, the first thing I do is I remember my parents. I offer my reverential regards to my father, respected Sri Manda Chittanagaru, and my respected mother, Srimati Mandhata Lakshmi Narasimhagaru. They are my first teachers. Teachers are my second parents. I studied under such great teachers. If I am like this today, I owe all this to my parents and my great teachers. Lest I forget, to begin with, I thank the organizers, Shri Ramrao Garu, all Bar Council members, all present here, for giving me this opportunity to be with you and share my humble thoughts. Law is an ocean. Somebody was mentioning in the morning. its horizons are ever widening, its depths are unfathomable. Therefore, nobody can claim to be a master of law. We are all students of law. Daily, if you are a sincere student, you learn something. Either a courtroom practice, or a discipline, or an ethics, something to do with truth and integrity, or something to do with the subject of law. So, there are many youngsters and there are many learned elders. So, I humbly first submit that my talk is only intended for the youngsters. I also learn like you from my seniors. So, my talk is only for the youngsters. Right. As mentioned in the morning and as it was in the first session, let this session also be an interactive session. In fact, I feel, if you agree, all of you agree with me, our sessions like this should not be at a podium, a lecture from a podium. We should have in the classroom a head table and then a chair, and then from there the address must be made. Then it gives an impression that we are interacting and the session is not a lecture session. That is my view of the matter. That is why I prefer to be here and instead of going to the podium and then make my submissions. At the end of a trial, be it a criminal trial or a civil trial, how many kinds of evidence will be before the trial judge? 3 kinds. Very well said. If the answer is coming from a junior, I request to stand up and then answer so that, as mentioned in the morning session, everybody will notice the person answering. Yes, right. What are those 3 kinds? Documentary evidence? No. Oral evidence? Material evidence. I mentioned what kinds of evidence will be at the conclusion of trial in a civil case or a criminal case. You are mentioning about material objects and material evidence. So therefore a question crops up as to whether material evidence will be there in a civil suit also. Any answer? That is, there are only 3 kinds of evidence before the trial court after the conclusion of trial. For example, in a given case, as you rightly said, oral evidence, documentary evidence and material evidence. Let us not go to the species of each genus. There are only species of the 3 main genuses. Let us not go into the subclassification of those evidences. My question is straightly whether material evidence will be there in a civil suit. Any answer? Let us go to Article 13. All of you are having books with you or cell phones with CPC. See, if you youngsters, if you come to sessions like this, I expect you to come with a notebook and a pen and also the relevant bare acts. Anybody can read Article 13, the last rule? Very quickly we have provisions as to, please read. Provisions as to documents also apply to material objects. So CPC contemplates that there can be material evidence also in a civil case, but they will be treated as documents and marking will be given as if they are documents. So when we go to civil rules of practice, what kind of markings we come across? A series is for plaintiff's documents or petitioner's documents, as the case may be. B series for defendant's documents or respondent's documents, as the case may be. Next. C series for court documents like a commissioner's report. X series for witnesses documents. A witness to answer and then files a document. So a Nadangal is summoned from the revenue office. An MRO or assistant mandal officer or revenue officer, Tahsildar comes and files the original document. It is marked in the X series. Right. Moral evidence, as you all know, is given of facts perceived by how many? 5 senses. What are they? Sanskrit is a very felicitous language. Difficult things can be remembered if you go to Sanskrit easily. Drusya, Sravana, Sparsha, Rasa, Gandha. Drusya, the power to see. Sravana, power of hearing. Sparsha, touch. Rasa, taste. Gandha, smell. So if we, by these 5 senses you are able to perceive any fact, moral evidence can be given. Hearsay evidence is inadmissible. The person who perceived by these senses must come and give evidence. Of course, we are not on the topic. There are exceptions to this rule that hearsay evidence is not admissible. There are 6 exceptions. You can, at your leisure, go through them. We are not on the point now. Then documentary evidence. Documentary evidence we can study under different heads. First is simple documents. Simple documents which do not require stamp duty or registration, like a notice, like a letter written, like a receipt for 100 rupees, like a will. The second category is documents which require stamp duty. Require to be stamped, like a promissory note, like a contract. Sale deed requires registration. I am not on that yet. Only stamp duty. The third category is requires stamp duty and also registration, compulsory registrable documents. This is one kind of classification. The second kind is, earlier one friend is mentioning, primary evidence and secondary evidence. Primary evidence is the very document original produced. Secondary evidence is under certain circumstances the original cannot be produced, or even if the original is there, still secondary evidence is permissible. There are instances in the evidence side. That is another classification. Another classification is documents which are compulsorily attestable and which are not compulsorily attestable. Like a will, like a mortgage deed, like a settlement deed, like a bond. So these are documents which are compulsorily attestable. So that's how documentary evidence. Then material evidence you all know. If it is a family portrait is there, it is the only one of its kind in a partition suit. It's a Picasso's painting being carried on from generations in the family. There is a dispute in the partition suit. That photograph may be, original photograph by Picasso may be a material object. In criminal cases, you know a weapon of offense is a material object. So this is how we talk about evidence. Of what evidence can be given? Evidence దేనికి అడ్యూస్ చేయాలి? Of what evidence can be given? Facts and relevant facts. Facts and relevant facts. Evidence can be given. Then, how many kinds of facts are there? See, unless you know, you cannot succeed as a lawyer or a judge. These are the fundamentals which have to be very thorough. What are they? Very good. Who answered? Very nice. Physical and psychological facts. I hope you are a student and not a teacher. Student. Okay. Faculty is not supposed to answer. But point goes to you. Physical and psychological facts. Physical facts we have seen which are material facts, which can be perceived by senses. Then psychological facts, state of mind, intention to commit an offense, motive to commit an offense. They cannot be perceived by senses, they have something to do with the mental attitude of the person. So this is how we look at the Evidence Act. Unless you have a bird's eye view of the law which you want to master, I think you cannot have a complete grip. So when you read an enactment, my suggestions to the youngster is read it from cover to cover first. Leave no section unread. Please read from cover to cover. Then read important provisions which are required in day-to-day life. So this is the secret of understanding an enactment. When you interpret a law, shortly you will have a lesson on interpretation of statutes. Whether it is a Noster Asakai rule, or Hayden's rule of interpretation, or a purposive rule of interpretation, you must have a bird's eye view of the law. Unless you know the entire law, you cannot in isolation interpret a law. For example, I tell you, see, law is such a very complex subject. You read, you feel you understand it. But you close the book and try to reproduce it, you cannot reproduce it. So a lot of hard work has to be put in. To easily understand law must be understood by illustrations. So you must illustratively learn the law so that you will never forget the law. For example, after a long session on confessions and admissions, if somebody asks you what's the difference between the two, it is very difficult to explain. So when you learn illustratively, the secret is you easily express what you know about law. Say for example, admissions. Admission fact need not be proved. Somebody says, I am a human being. Somebody says, I went to Delhi. These are all admissions. But the subtle difference between confession and admission. Admission we all know is a genus. Confession is a species. It's also an admission. But it is a separate species among the admissions. So one person said, I saw her drowning. Is it an admission or a confession? I saw her drowning. Lunch is good? Lunch is good? So we are having a session or siesta? So I want you to answer. Even if the answer is wrong, no problem. It's a simple question. You see, so many youngsters are there, probably practicing young aggregates are also there. They're hesitating to answer. That is the reality of legal knowledge. I saw her drowning is an admission because on that admission you cannot convict him. He may be a witness. He saw her drowning. Another person said, I drowned her to death. What is it? It's confession. This is how you must learn law. This is how you must learn law. Right? Similarly, what's the difference between onus of proof and burden of proof? Onus is a equivalent word from Latin for the word burden. But still, is there a difference is my question. Is there a difference?
Yes.
What's the difference?
Legal burden, evidential burden.
Very nice. Legal burden. See, when they are almost the same, why are you differentiating between the two?
Evidential burden will shift both of
them. Onus of proof is evidentiary burden.
Yes.
During course of trial, it will shift from side to side. Yes. Very well said. Legal burden never shifts.
Yes.
What is the example? It's a criminal case. The burden of proof is always on the prosecution. It never shifts. Even in a civil case, burden of proof never shifts. Give me an example of burden of proof which never shifts. A suit for declaration of title. He who comes to court, he who asserts must prove. Right? A suit on the foot of a promissory note. The defense is forgery. The burden is always on the plaintiff. Legal burden is always on the plaintiff, it never shifts. But evidentiary burden shifts. For example, in a suit on the foot of a promissory note, the defense taken is, yes, I executed the promissory note, execution is admitted, but the consideration is denied. On whom does the initial burden lay? The initial burden lies on the defendant. Why? Why? Which law says that? Which law says that? Admitted fact need not be proved. Execution is admitted. Plaintiff need not prove execution. But the defendant counsel says, let him prove also passing of consideration. He is accepting that consideration is passed. Why should we ask the defendant to first prove? Presumption is there. So, in a civil law, every issue must be framed in the affirmative. Every issue of law and fact must be framed in the affirmative. That is the first principle. This is also contained in the Evidence Act, onus of proof and burden of proof. But when there is a rule reversing the burden of proof, then we frame the issue with a negative. So when the execution is admitted, we are framing an issue whether the suit promissory note is not supported by consideration. Is not supported by consideration. Why are we framing such an issue? Because under section 118 of the NI Act, there is a presumption which reverses the burden of proof or the onus of proof. That's how even framing of the issues is very, very important. So when you commence a trial, you must read the issues framed by the court. Otherwise, the whole exercise of trial will be a sheer waste. And injustice may be done if the issues are not properly framed. So this is the first care you have to take. Similarly, under various chapters of the CRPC also, there are provisions dealing with how charges should be framed. Sessions case, there are other sections. Summons case, other provisions. Summary trial, other provisions. Warrant case, other provisions. Under each chapter, there are sections which say how the charge should be framed, where charge is necessary. So this is how we have to know the basics of the Indian Evidence Act. Unless your foundations are strong, you cannot perfectly understand the niceties of law. Unless you know also the niceties of law, you cannot become a complete lawyer. Or a judge for that matter. So what we need here is a complete understanding of the law, right from the fundamentals to the niceties. This is possible only when you thoroughly read the law. So this is one aspect of the matter. Then what I want to tell the youngsters is about ethics. You must, like pace is the index of the mind, dress is the best introduction. Wherever you go, you must go very well neatly dressed. First impression is the best impression. Then in the morning also it is said, communication skill. See how you sit in a chair in a court hall, how a judge sits in the chair in the court hall, the pose, the poise, the language employed, then the tone, the pause in the language, the intonation, all these things are very, very important either for a judge or the lawyer. This is possible when you are a voracious reader. You must read. Every day I may tell you that you should spend 1 hour time on reading. Be it old Supreme Court judgments prior to 1975, because my father told me to read those judgments and benefited by it. Whatever may be the subject of law, read all judgments of the Supreme Court. By the time you complete reading 100-200 judgments, you will have a grip of our legal language, and also many settled legal questions also you will know. Read autobiographies and biographies of judges. Every year there will be one book which will have maximum sales and a Booker's Prize. Read those books every year. Nowadays you have the advantage, you can go to the internet and see what is the book this year which has highest sales. You need not select for yourself your own books. The internet already has selected the book and kept it there. You please purchase and read it. So these are all very, very important. I am talking about issues and presumptions. Is presumption evidence? Is presumption evidence? Presumption is not evidence. Just now we are discussing. Presumption is only a rule of evidence. It points out on whom the initial onus of proof lies. Presumption is not evidence. It is only a rule of evidence. It points out on whom the initial onus of proof lies. Then, how to understand law? In the morning session, there is a wonderful interaction on interlocutory applications. May I ask you, how many interlocutory applications are there? How many interlocutory applications are there? Very difficult to answer. They are myriad and manifold. Imagine an application you can file it under 151. But how many kinds of interlocutory proceedings are there? You know the distinction between the two, very subtle distinction. How many kinds of interlocutory proceedings are there? Only two. That is what the CPC says. 75 and 94. Anybody please read section 75? Please read, if it is possible. This is how you must understand the law. See, the interlocutory applications are myriad and manifold. There are provisions in the CPC under which you can file the interlocutory applications and seek reliefs during the pendency of a suit or a first appeal, which is a continuation of a suit. But the point is, how many kinds of interlocutory proceedings are there? The answer is 2. Section 75, what does it say? Yes, from this side. Please get up and read so that everybody will recognize your talent.
Section 75. Power of court to issue commission. Subject to such conditions and limitations as may be described, the court may issue a commission to examine any person, to make a local investigation, to examine or adjust accounts, or to make a partition, or to hold a scientific, technical, or expert investigation, or to conduct sale of property which is subject to speedy and natural decay and which is in the custody of the court pending the determination of the suit, or to perform any
Administrative act. Now read section 94. Supplementary supplemental proceedings. In order to, there are two kinds of proceedings. One is incidental, you have read. The other is supplemental proceedings. Yes. In order to prevent the ends of justice from being defeated, the court may, if it is so prescribed, issue a warrant to arrest the defendant. So arrest during pendency of the suit, right? Yes, sir. Next, direct the defendant to furnish security to produce any property belonging to him and to place the same at the disposal of the court or order the attachment of any property. Arrest attachment. Yes, sir. Grant a temporary injunction. Next, appoint a receiver of any property. Receiver. Yes, sir. And make such other interlocutory orders as may appear to court to be just and convenient. So these are the 5 relief which the court can grant under supplemental proceedings. What is the intent of legislation in separating these two? Incidental proceedings and supplemental proceedings. Supplemental proceedings do not come in the aid of judgment. They only preserve the property till they also protect the parties, because ultimately the decree should not become a paper decree. But so far as these incidental proceedings are there, they come in aid of the judgment. Say for a suit for encroachment. See, 10 cents is encroached is the case of the plaintiff. Defendant says no encroachment at all. How to determine? A commissioner will be appointed. He will determine the encroachment is there or not. If there is an encroachment, what is the extent of encroachment? So the commissioner's report comes in aid of the judgment. That is why the legislature has divided these proceedings into two categories. Please go through at your leisure. AR 1966 Madras 441. So without the aid of section 75, your decision will be incomplete. So this is how you have to read CPC. See, you must, when you read 75 and 94, you must immediately get a doubt as to why this separation. So when you read old decisions as suggested to me by my respected father, you will get answers to all these questions unknowingly. Then I was mentioning to you some courtroom practices. We have now a bird's eye view of some of the important provisions of the Indian Evidence Act. Now we shall, if time permits, turn to some courtroom practices. As I was mentioning, in the courtroom, how you sit, how you stand up. When you stand up, you button up your coat. When you sit down, you unbutton your coat. All these things do matter. People will observe you. Right. Whether the court can reject at any stage irrelevant evidence, evidence which is inadmissible. Please, one of you read Order 13 Rule 3 of CPC. CPC is both, in my humble view, a substantive and also procedural law. Any person, any other person, any other student, youngster? Yes, please read.
Rejection of irrelevant or inadmissible documents. The court may at any stage of the suit reject any document which it considers irrelevant or otherwise inadmissible according to the grounds of such rejection.
See, such a power is given to court. The court can, even if by mistake some document is admitted inadvertently, some evidence is taken on record, though irrelevant, it can be rejected at any stage. See, you must be well equipped when you ask a court while arguing a case to reject an evidence. Then the court may say, can you point out a decision? You can say, instead of a decision, I can straight away point out a provision of law and then succeed on the point. So this is how you must read CPC. Right. Then is there a provision for the production of evidence, that evidence must be produced in a particular way? So far as criminal law, there is no doubt, because we know the cardinal rules of criminal jurisprudence. The burden is always on the prosecution, it never fits. Then the cobweb, golden thread which runs through the cobweb of criminal jurisprudence, that 9 guilty may escape, but 1 innocent shall not be punished. And the advantages to the accused to explain away incriminating circumstances in the evidence in 313 examination. Then stone silence. Stone silence can be maintained. Stone silence can be maintained. he cannot be a witness. He cannot be called as a witness. They can then in the 313 he can file his documents. So many advantages are there. But my question is with regard to civil law. Is there an order of production of evidence? Please read section 135. Audible? Yes. Anybody 135?
Exemption from arrest under civil process.
Yes. 135 of the Evidence Act.
Order of production and examination of
So there is also a provision which says in which the witnesses must be produced. Right.
which witness are produced and examined shall be regulated by the law and practice of the time being related to civil and criminal procedure and in the absence of any such law by the discretion of the court.
Yes. So court has a discretion. Court has a discretion when there is no law under which a witness should be examined. Right? See, so much of power to a court. Next. Also see Order 18 and Order 41 CPC.
Hearing of the suit and examination of
So CPC also says hearing of the suit and examination of witnesses. So this is how you have no discretion as a lawyer. The court and the CPC guide you as to how the evidence should be adduced. Is it not? Right. Please sit down. Right. Similarly, I was mentioning about some of the provisions in the CRPC. Chapter 23, please note down. Chapter 23 and 24 of CRPC deal with charges, summary trial, summons trial, warrant trial, sessions trial, and so on. There also there are provisions as to how charges should be framed if necessary and the order of examination of witnesses. Then, please see Order 18 CPC. Why are we always asking the plaintiff to begin? Order 18. Anybody? Rule 1. Right to begin. So plaintiff has a right to begin. So plaintiff will always adduce evidence unless issues framed show that the initial onus is on the defendant. Right. I was mentioning about presumptions here that you must always keep in mind. Then, reading the same issue, one counsel contends the burden is on the defendant. The opposite counsel contends that the burden is on the plaintiff. You are a judge. How will you decide? Say, for example, whether the sued promissory note is not supported by consideration is the issue. Plaintiff's counsel says, because there is an issue in the knot and there is a presumption, let the defendant get into box first. Defendant counsel says, he is accepting that the consideration passed. So let him get into the box. You are the judge, you have to write an order. I want reasons. We know the answer. So, a judge's duty is to sustain the conclusion with reasons. You read it as a statement covering the word whether. Forget the word whether and read it as a statement. Whether the sued promissory note is not supported by consideration. Sued promissory note is not supported by consideration is the statement. Who will make it? Defendant is making it because plaintiff will never say sued promissory note is not supported by consideration. So then he who asserts must prove. Therefore, in view of the presumption and the assertion, the burden is on the initial onus is on the defendant. you will write an order, it will be sustained. Right? This is another courtroom practice. So for mischiefly some advocates for a adjournment content like this and get adjournments and get away. Senior advocates better know this than the youngsters. Right. They intentionally fight if they want an adjournment from the court and then go outside the court hall and have a cup of tea together. So this is how the judge must be prepared for every situation. Then party must be first examined, then only party witnesses. Supposing a plaintiff is examined or a defendant is examined, a supporting witness has come. He is not supporting the party who has called him as a supporting witness. Can he be examined? The advocate says, Milord, the honorable judge, the witness is not supporting my claim. He may be declared as a court witness. Yes or no? No, the situation, what is the, then if it is no, answer is no, what is the option to the counsel? Declare the witness hostile in our common sense, normal terms. Seek permission to put questions in the nature of cross-examination. Seek permission to put questions in the nature of cross-examination is what the law says. Hostile is our language which we coined for our convenience. Then witnesses can give opinions. A witness comes and gives an opinion. The court is recording. You raise an objection, your opinion cannot be given. The court says, sustain your objection by supporting, striking a provision of law or a decision. You must be, as a trial court lawyer, be thorough with all these things. Otherwise, injustice will be done. We, in drawing a result from the evidence that is adduced is the duty of the court. It's a judicial function. A witness cannot give opinion, as rightly said, unless he is called as an expert or he is given to speak about a custom in the village which he has heard from his forefathers. So, 1957 Supreme Court, 857, Mubarak Ali's case says that is the general rule of law. He will only give evidence. The court will perform its judicial function of arriving at an opinion after appreciating, evaluating, and then in determining what is truth or what is not truth. Right. In chief examination, leading questions cannot be put. Nowadays, this does not arise because you simply file chief affidavits, unfortunately. But is it an absolute rule that leading questions cannot be put in a chief examination? Is it an absolute rule? It is not. Relationship can be asked if it is admitted. All admitted facts, introductory facts can be led in evidence when leading chief examination. Right. I was mentioning about attested documents which are compulsorily attestable. The law says, even though attestation definition says attestation must be by two witnesses, to prove the document one witness also can be examined. But if one witness is examined, unless his evidence is complete about attestation by two witnesses, the evidence regarding attestation is incomplete. Supposing two witnesses attested the document at different times, one in the presence at the time of execution, the other later by taking an acknowledgement from the executant attested the document. then one witness cannot speak of attestation by two witnesses, then both the witnesses must be examined. That is the law. Otherwise, the requirement of law is not satisfied. Right. Two witnesses are there. One witness is examined in chief. The other witness also will be examined because list of witnesses is filed. It is a rare practice, unfortunately, except in courts like Kakinada, list of witnesses will not be filed. But in some offices we do that. So another attester is likely to be examined. What is the course as a cross-examining counsel? What will you do? One witness, one attestor's chief examination is over. Or for example, in a Panchanama or a recovery Panchanama in a criminal case, one Panch witness is examined in chief. Another Panch witness will be examined later. You are called upon to cross-examine the first witness of the two witnesses. What is your duty to your client? You will request that the other witness also may be examined. You will cross-examine both the witnesses at one time. Otherwise, you will be doing injustice to your client. So, these are all courtroom practices. Otherwise, the witness will know the line of cross-examination, he will reflect, and he will come prepared with an answer, and then even before a question is put, he is already ready with an answer. You got my point? Yes or no? Loud? Yes. So, this is how you must be prepared as a trial court lawyer. Even in the appeal, when you are arguing, when these two witnesses are separately examined, you can point out to the appellate court that this is the injustice done because the trial court and the trial court advocate do not know the trial court practices. Yes, two witnesses were brought. Then one witness is being examined. What is your duty as a judge or a lawyer? When one witness is being examined, the other witness should not remain in the court hall. He should be sent away. So these are the things you have to take care of as a trial court lawyer. Then character. Generally, unless character is put in issue, character assassination in cross-examination is impermissible. So sometimes questions about character are being put. The judge says it has nothing to do with the character. How to convince a judge? Then you must know what is the definition of character. So you must be prepared like that. See, sometimes senior advocates, when they have no case, they resort to character assassination of the witness. So you must stop them there. Otherwise it will prejudice the judge when he is appreciating the evidence. So how to stop the judge? You must know what is the character. Then the question we can put to ourselves is, what is a character? Precisely you must know as a lawyer, because you have to tell the judge this is the character. This question relates to character only. Character has two parts. One is reputation. The other is disposition. What is reputation then? Reputation is the credit you have in the estimation of others. Reputation is the credit you have in the estimation of others. What is disposition? It is only known to closely associated persons. When you get up, whether you fight with your wife, what are your habits, whether you drink in the night, whether you get up with a hangover. These are all dispositions. So these are all the things a person must bear in mind. Then a witness is summoned to produce a document. He produced a document. One of the counsel makes a request to the court that I will cross-examine the witness. Yes or no? He is summoned to produce a document. He produced a document. One of the counsel makes a request to permit to cross-examine. Can there be cross-examination without chief examination? The answer is clear. The answer is clear. Where is the chief examination? He is not a court witness. Who will chief examine? Please go through section 139 of the Indian Evidence Act. Somebody may read it. He produced it. Wonderful, sir. He cannot be allowed to be cross-examined. Cross-examined. Very well said. Then custody of document is also important. Whoever is filing a document must explain the custody. Like a father wrote a letter to the son, the letter must be either with the son or in the dead letter office if it is written. Anybody else cannot produce it unless he explains the custody. So when a document is being produced by a person, the cross-examining counsel must be ready and see whether the witness is competent to have custody and produce the document. Then a statement recorded by a magistrate is sought to be relied upon by the prosecution. It generally happens. Some confessional statements, some other statements, dying declarations, in property identification statements, suspect identification statements. The defense counsel raises an objection that the magistrate did not properly follow the procedure. Therefore, I want to cross-examine the magistrate first before this evidence is admitted in evidence. See, that the magistrate failed to properly discharge his duties writ large on the record, but still can we permit him to be cross-examined by summoning the magistrate? Please see section 121. One of you may read it.
No judge or magistrate shall accept upon the special order of some court of which he is subordinate be compelled to answer the question as to his own conduct to court as such judge or magistrate or as to anything which came to his knowledge in court as such judge or magistrate, but he may be examined as to other matters which occurred in his presence which he was quiet.
So, he cannot be summoned as a witness for the procedural irregularities to be proved. Because recently one case has come just before my retirement, one magistrate was summoned without looking at this section 121. If a magistrate is to be summoned for this purpose, the permission of a superior court is necessary. He should not be summoned generally. If it is inevitable, the superior court must permit. Then logical relevancy. Relevancy is of two kinds: legal relevancy and logical relevancy. What is the difference? You come across privileged communications between wife and husband, spouses, between lawyer and a client. So they are logically relevant, but they are not legally relevant. Then this generally happens. Plaintiff in a suit for immobile property examines himself. He wants to examine his neighbor. He says, as a supporting witness, to tell that he is his immediate neighbor, he is residing there since a long time. The plaintiff's document also, the boundary is that of the second witness, that is the person who is called as a witness. Then when that witness, that neighbor who is residing in the adjacent suit property, can be called upon to produce his document, These are all courtroom practices. The court has to take a decision then and there. See, you produce your document, the cross-examining counsel will say. He will say yes or no, then an adjournment. But if you know the law, the trial will not prolong. One of you may read section 130.
Witness not a party. O witness who is not a party to his suit shall be compelled to produce steadily to any property or any document in which he holds any property as pledgee or mortgagee or any document the production of which might tend to eliminate unless he has agreed in writing to produce them the person seeking the production of
so the general rule is he cannot be compelled to produce. Right? So if the judge knows the law, there ends the matter. So a comprehensive knowledge of all the provisions of the Indian Evidence Act is necessary for courtroom practice while receiving oral and documentary evidence. Unless you know what is a leading question, you cannot. Unless you know what is a document. What is a document? Even a stone is a document. How do you define document? Section 3 is all right, but I am telling you in common parlance. What is a document? Something chiseled is also a document. If something is chiseled on a stone, it is a document. So any surface on which human thought can be expressed is a document. Do you agree? That is how you must learn the law. See how cross-examination can be curtailed. See, a witness came and gave evidence. He spoke certain facts. The first question in the cross-examination is, what all you have said is contained in a document, is it not? He says yes. Moral evidence of a document is inadmissible unless the document is produced. So the entire evidence he has given regarding the document becomes inadmissible and irrelevant, which can be rejected. So that is how you must know comprehensive knowledge of law when you are either recording evidence or cross-examining a witness. So next, one more courtroom practice, I will start with that. I have to also rush to the airport. See, a document is in dispute. The plaintiff says it is written by the defendant in his own hand. He is the scribe of it. The defendant, according to the plaintiff, deliberately denies his handwriting. There is no contemporaneous document of the same period rather with the handwriting of the defendant. Then how to go about? Where is the document to compare? My question itself said there is no contemporaneous document for comparison. So the cross-examining counsel says that is how these are important as a trial court lawyer, as a trial court judge. He seeks permission of the court and asks the court officer to give a piece of paper to the witness. He will dictate a paragraph to him. He will design such a paragraph in advance with the same language which is employed in the disputed documents. Then he will dictate that paragraph. The witness in open court in the cross-examination reduces into writing what is being dictated. You see, every witness, every person will have a peculiar style of writing. It will be specific, it will be distinctive, it will be peculiar, it will be in common for him to express a certain word like this, certain figure like this. He will maintain same size of letters, same distance between the letters. He will have maintained the same slant. He will have the same strokes. he will maintain the same margins. When he begins a sentence with a, he will write a like in one manner. When the a comes in the middle of the sentence, he will write it differently. So that is how a dictated matter will be prepared. The matter to be dictated will be prepared and dictated to the witness. He will write down, he will reduce into writing on that slip of paper. It will be given to court, it will be marked in the C series. Because it is a court document, it will not be returned either to the plaintiff or to the defendant. Then the court will compare these signatures. If necessary, these two documents will be sent to an expert. This is how you must understand the law and the art of putting the law into practice. What is knowledge? Reading and then retaining the knowledge is, reading and then keeping it in your memory is knowledge. What is wisdom? What we have discussed now is wisdom. What we have discussed now is wisdom. So if at the end of the session there is a value addition to your knowledge banks, I am happy, man. Thank you so much.
Thank you, sir. It is a treasure. You get something out of it. You just taste it. We will look for opportunity for this session. In an entire day, we can learn. Let us hope, wait for another day, where from the morning to evening, this will help especially the trial court, advocates as well as the judges, to expedite the trial. Thank you, sir. All of our
చిన్నపిల్లలంటే చాలా ఇష్టం. నా హాబీ ఏంటంటే వాళ్ళతో గడపడం. Actually, no more to complain.
I know, sir. In fact, Justice Koyanram sitting beside me is suggesting me that we shall bring a volume on this, and so that all of us can be benefited by that. And he may not aware, because in peculiar circumstances, my lord, he is in doubt whether to come or not to come because of various problems. But for all of us, we said he likes especially the youngsters, and he is having that regard for the institution of judiciary and the profession, legal profession. But we are thankful to you, sir, for your time, especially today. We know how much under what stress my lord is there. It may not be able to share with you, in spite of the difficult times, traveled all the time, and he was present here with us. Thank you, sir. Thank you very much. Moment. I request Chandrasekhar Reddy and Chidambaram to come and or a memento to my lord.
Thank you, taking you all of you.
Now the second session also successfully completed. అరవింద్ ఆయన యోగా ఇంకా ఉంది ఇంకోటి ప్రశ్న ఉంది
వచ్చారు కదా మొదలు పెడతారు వచ్చారు.
Now the next session is beat the stress, win the life. Because you know, today itself we are under the stress. I know. Some of the people travel all the way, sleeping, having sumptuous lunch. That's why I told you, not full lunch, sumptuous lunch. Only sufficient to sustain till evening. That's why I had only vegetarian, one course lunch, so that you can be active till evening. Please follow. Dinner you can have sumptuous. Now,
ఒక్క నిమిషం అనౌన్స్ చేస్తారు పిలుస్తారు నేను వెళ్ళట్లో
Ladies and gentlemen, now we are moving to the last session. The last session is on the beat the stress and win the life, and this will be delivered by Dr. Professor Arvind Nithalapati. So now I take this opportunity to invite the guest. I request Dr. Professor Arvind Nithalapati to come over the dais and adore the chair. Please, sir. Simultaneously, I request Shri Vaishnavi to accompany the guest, and I request Shri Shrai Praniti to present the sapling to Dr. Professor Arvind Nithalapati, sir. Thank you so much, sir, for being here with us. Now, I request Shri Arvind Nithalapati, sir, to make a presentation on the beat the stress and win the life. Please, sir.
From which place are you? From which place are you?
Good evening, all of you.
Lights off.
Good evening. Assume for a while that you are all students. By profession, I am a teacher, a professor. I work in an engineering college. We very rarely come across this audience. Only 5% of our audience pay attention. Rest of them will be in their own world, doing their own work. And I find this amazingly a different one. Highly motivated, knowledgeable, learned people I find here. And my topic is how to be happy in life. In happiness index, India is among the bottom strata. Of course, who survey and what's the scope of survey, that also matters. I'm the president of Center for Social Psychology, Andhra Pradesh. Before I go to my subject, I submit what is Center for Social Psychology so that I make some relevance to today's talk. Psychology studies human thinking, behavior, and the relation between thinking, behavior, character. How thinking influences behavior, how behavior influences thinking in individual plane is psychology, whereas social psychology is how our environment, our social milieu
influences individuals. That's what we study. Before coming over here, I asked one of my lawyer's friend, should I go there in white? He asked me, it's a lawyer's orientation, will you go there in white, black coat and white t-shirt? I said, no, I will be myself. Already there is overlapping. More than judges, mafia gangs are delivering justice in India. And policemen have become also judges. Every day is happening. Instant dispense of justice. And there is widespread acceptance of this also in the recent past. It's happening in Andhra Pradesh, it's happening in Uttar Pradesh, it's happening across India. Unfortunately, with the increasing public acceptance, instant justice is very unfortunate. Then what for in the legal system? Well, I can deliver justice on my own and I go scot-free. So in this scenario, lawyers need to have a lot of guts. Judges need to have a lot of guts. And to have guts, to have courage, we need to be happy. So my first slide shows back please. This is it. This is what I request you to understand. Happiness, many of us think, will be at the end of something. But we need to understand every day of life has something to do, something to enjoy. It's not at the end that there is happiness. And next one. Next one, please. Then what is, the topic is beating stress, winning life. What is stress? I find many youngsters here, some of them might have been unmarried, some of them have been married, and some of them are trying to find their fiancé here. It's a big stress in life. And who got recently married, there will be brain gain. అసలు మా మామయ్య ఆ పెద్దాపురం సంబంధం చూస్తే మా నాన్న దిక్కుమన్నాడు, నాకు నిన్నిచ్చి కట్టాడు. దిస్ ఈస్ హౌ ఇట్ బిగిన్స్. ఫ్యామిలీ డ్రామా. We miss the purpose of life, that is leading happy life, by submitting our ego. It is ego that spoils relations. There is one lawyer, famous lawyer in Guntur. Clients are scared of reaching him. Clients are scared of approaching him. I don't want the name. I'm the guy who did that. If you look back at yourself, you understand who that category of practitioners. What right have you got to score your clients? So, is ego, the parental ego, according to psychology, that spoils human relations. And what is this parental ego? As a teacher, I find, when I ask any girl, who is your number one enemy, 9 out of 10 say, my mother. Today is Mother's Day. Adult girls find their mother most villainous on earth. If you ask boys, are you out on me? Padda villain, inkevaru sir ma nana. Why do you think so? Paddaka nase sir. Why is this happening? Parental ego. We don't try to understand, we don't try to empathize. When someone comes to us, what is his state of mind? What is his predicament? What's the context he is with me? If we empathize, we get connected with the people. It is true in case of lawyer, it is true in case of doctor, it's true in case of teacher, it's true in case of any public servant who has to deal with people. We start with our ego. నేను ఇంకెంత గొప్ప నేను ఇక్కడ కూర్చొని ఉంటే నువ్వు కూర్చొని సమాధానం చెప్తావా అని ఒకడు మొదలు లోపల. వాట్ ఈస్ దట్? దట్ ఈస్ పేరెంటల్ ఈగో. So, I submit we need to submit this parental ego and become adult, child, responsible, empathizing. Very first thing, if we do to understand others, we make good practitioners. As a teacher, as a lawyer, as a doctor. Next slide, please. Stressors are of two types, external and internal. External factors are always there. Internal factors are the ones we invite because of our bad temper, because of our bad thinking. Today, except those who are in government jobs in India, every other profession is quite uncertain. There is insecurity. There is uncertainty. You do not know what life will be tomorrow. This is a great stressor. And by definition, what is stress? It is a challenge or a demand that we think is beyond our capacity to deal with, to manage with. కోపం మనం అనుకుంటాం, నేను గౌతమ్ బుద్ధ శిష్యుని భలే మేనేజ్ చేసుకుంటా కోపాన్ని. కానీ ఎవడన్నా వచ్చి కెలికినప్పుడు తెలుస్తుంది, పక్కది తెలుస్తుంది. అసలు వాడెంత మనిషి అండి, అదే కోపం అండి అంటారు వాళ్ళు. మనం అనుకుంటాం నేను గౌతమ్ బుద్ధుని అండి అనుకుంటాం. Anger is an emotion, so also other emotions shall not be suppressed. మొన్న లాయర్ కనపడ్డాడు, బాగా చిరాకున్నాడు, కోపంగా ఉన్నాడు. నువ్వు అట్లా ఉండవే, ఏంటి అట్లా ఉన్నావు అన్నావు. నువ్వు అట్లా ఉండవే అనగానే వాడు చాలా హ్యాపీ ఫీల్ అయ్యాడు. లేకపోతే చెప్పేవాడు కాదు. యువర్ బై నేచర్ వెరీ కామ్ కూల్ అనగానే వాడు హ్యాపీ. ఇప్పుడు ఎందుకు అట్లా ఏంటి రీజన్ అప్పుడు చెప్పాడు. ఏం చెప్పాడు, ఒకడు వచ్చాడు క్లయింట్, 3 గంటలు తిన్నాడు, చెప్పిందే చెప్తున్నాడు. అదే చెప్పాడు, ఇప్పుడు 10 సరే నేను లెక్కేసి చెప్తున్నా వాడికి, అయినా సరే గంటల్లా అన్నాడు. ఏం చేసావన్నా, పొగ పెడతాను అన్నాడు. అదేంట్రా? Anger management has one principle. If you are angry with the wrong, you are on the right wicket. If you are angry with the person, we are at the losing end. So any professional, a practicing professional, has to practice this practice of being angry with the wrong, not with the person. External factors, when stresses, we often will be carried away by stronger emotions. ఒకటి వస్తాడు, వచ్చి అసలు చూపులోనే మనకి చాలా విషాదం కనపడుతుంది. ఒకడు రాటం ఎత్తుక్కుంటూ వస్తాడు, ఏం కనపడితే ఎత్తుకెళ్దామా అంటే ముఖం అట్లా ఉంటుంది. వీటిని మేనేజ్ చేయటం అనేది ఒక ఆర్ట్ అది. అండ్ ఆర్ట్ కెన్ బి ప్రాక్టీస్డ్. దట్ ఈస్ వాట్ ఐ వుడ్ లైక్ టు డ్రైవ్ ఇట్. ఫినాన్షియల్ ప్రాబ్లమ్స్, దే ఆర్ దేర్, దే ఆర్ రియల్. లా ప్రొఫెషన్లో వచ్చినాడికి రేపు కొత్తగా ఐటీ ఇండస్ట్రీలో కొత్తగా వచ్చినాడు పరిచయం అయ్యాడు అనుకోండి, ఇద్దరు వెళ్ళారు అనుకోండి, వాళ్ళందరూ నీ జీతం అంతరా అంత అడిగాడు, ఎందుకు అనవసరం వాళ్ళు 40,000 లేకపోతే లక్ష అంటే లక్ష వీడికి ఎస్బీటీ మొదలు. Beyond financial problems, our interpretation of financial problems matters. So, there are several stressors. కొంతమంది ఇందా చెప్పాను మీకు పిల్లల సంగతి. సరే, ఆడపిల్లలు మొట్టమొదటి అమ్మ, మగపిల్లలు మొట్టమొదటి, మరి సెకండ్ ఎవరు రా, ఎవరు నువ్వే అంటారు అది, అంటే టీచర్స్. ఫ్యామిలీలో ప్రాబ్లమ్స్ అండి, చిల్డ్రన్ తోటి ప్రాబ్లం అండి. అప్ టు ఏ చైల్డ్ క్రాసెస్ ద ఏజ్ ఆఫ్ అడోలసెంట్, ఆ ట్రాన్స్ఫర్మేషన్ స్టేజ్ వరకు మదర్ ఈస్ ద మోస్ట్ డియర్ ఫిగర్, ఫాదర్ ఈస్ ద మోస్ట్ డియర్ ఫిగర్ ఫర్ ఎ చైల్డ్. Once they get into adolescent age, entire scenario goes reverse. So, lawyers ఎవరన్నా adolescent లోకి ఏజ్ లోకి వచ్చిన పిల్లలు ఉంటే వాళ్ళతో సాయంత్రం పూట కూర్చొని ఆనందానండి, లేకపోతే మీరు శత్రువులు అవుతారు, మీ ప్రొఫెషన్ మీద అది పడుతుంది. హ్యావ్ సప్పర్ ఆర్ డిన్నర్ విత్ దెమ్. లంచ్ యూ కెనాట్, because they will be in school or college and you will be elsewhere in profession. At least have supper together. ఆ సప్పర్ తినేటప్పుడు ఎన్ని మార్కులు వచ్చినాయిరా అని అడగబాకండి, సత్యరం మీరు. కూర బాగుందా లేదో అడగండి. అప్పుడు ఏంటంటే కోపం వాళ్ళ అమ్మ మీదకి వెళ్తుంది, మీరు వెళ్తున్నారు. ఒకవేళ మీరు వంట వండుంటుంటే ఇంకో టాపిక్ ఎత్తండి, then you will be safe. When you are happy at home, you will not undergo very strong emotions and disturb yourself. You will find time to be cool and concentrate on your profession. ఇక ఇంటర్నల్ ఫ్యాక్టర్స్, ఒకసారి టీచింగ్ నుంచి లీగల్ ప్రొఫెషన్ లోకి వెళ్ళిన ఫ్రెండ్ ఒకటి కనపడ్డాడు. టీ రా అన్నాడు. వెళ్ళా. అసలు నీ జీవితం ఎంత అదృష్టవంతుడు, 20 ఏళ్ల కింద చదివావు, అదే రోజు వాడుతున్నావు క్లాసుల్లో, పెద్ద ప్రొఫెసర్ నేను రోజు చదివేసేస్తున్నా అన్నాడు. అయినా సరే కుదరటల్లా. When you enjoy learning, this struggle will not arise. When you feel you are learning and when you enjoy your learning, you don't feel its burden. Otherwise, it's essentially a stressor. ఇంకా కొంతమంది ఉంటారు, లా చాలా మంచి ప్రొఫెషన్, ఈ ప్రపంచంలో దిక్కుమాలి నాటిల్లో లాయర్ ప్రొఫెషన్ అండ్ pessimism. You degrade yourself, you belittle yourself, you look down yourself, and you look at everyone and everything low. Nonsense. This is also a stressor that comes from within. And rigid thinking. the more flexible we are, the more elastic we are, the more evolving we are, the happier we are. Unfortunately, some people have rigid minds. I am like this, I don't change. This is going to be a big stressor. Everything in us, around us, keeps on changing. If we don't accept, if we don't invite, if we don't adopt to change, it's going to be stress. It's going to be a damaging factor, a disturbing factor. And feeling that we need something more. Next slide, please. So these are various people we come across. You can see different faces. I would like to ask you, suppose in the morning you met a greedy face, how would the day will be? పొద్దున్నే ప్రపంచం అంతా తినేయాలన్న మొఖం కనపడింది అనుకోండి మీకు, ఆ రోజు ఎలా ఉంటుంది? ఇంకోటి, అసలు వాడిని చూడంగానే నేను ఎందుకు చూశాను పొద్దున్నే అని మీరు పశ్చాత్తాపడ్డారు అనుకోండి. ఇఫ్ యూ రిగ్రెట్, హౌ వుడ్ బి ద డే? ఇంకా కొంతమంది ఉంటారు నాన్ ఎక్స్ప్రెషన్, అసలు ఆ మొక్కల్లో ఏ ఎక్స్ప్రెషన్ ఉండదు, గోళం చూసిన వాళ్ళు చూసిన ఉంటాయి. వుడ్ యూ లైక్ టు ఇంటరాక్ట్ విత్ దెమ్? నిన్న క్లాసులో ఒక అమ్మాయి, పావు గంట అమ్మాయి అంటే చూస్తున్నా, బేతంచెర్ల బండకి ఆ మొక్కానికి ఏం తేడా లేదు. అర్థమవుతుందో తెలీదు, అర్థం కావట్లేదు తెలీదు, ఎంత అందలేదు. Can anyone succeed in life with that face, expressionless face, lifeless face? And by default, if we are cheerful, take it for granted. We have studied people who have been successful in various professions. Most of them have been cheerful. Whatever be the stress they experience, whatever be the adversity they face, whatever be the difficult challenges they have undergone, they have been cheerful. And with a cheerful face and always energizing mind can help us in winning life. And it is possible for anybody to succeed in one's profession, to lead a happy life, if we have two things. One, carrying a cheerful face by default, come what may. Second one, energizing ourselves every minute of our life. Next please. I would like to drive one point, that is the significance of being happy. If you are happy, you are healthy. Health is psychosomatic. And if you are healthy, you are physically, mentally and socially strong. Social life makes a lot of difference. It serves as a cushion when we undergo extreme emotions. One Dr. Rajan, a cancer specialist, today morning told me, people who suppress their emotions, particularly their sorrow, their disappointment, if they suppress, if they don't vent out, are likely to suffer from cancer. That's his observation. So, health is psychosomatic. We live social life. ఇప్పుడు మనం ఎట్లా ఉంటున్నాం? మా ఇంటర్మీడియట్ బ్యాచ్ we had a meeting in Hyderabad once. Two of our classmates came there. One asked another, where do you live? That fellow, suppose A said in high-tech city. B said in high-tech, where is it? Then it's so street. So the street, where? An apartment. Which apartment? Some name. That apartment, which floor? Same floor. One fellow is in one apartment, other one is in another apartment. They don't have relation. In Facebook and WhatsApp, we get connected with people in Adelaide and Cape Town, but we are stranger to our neighbor. This type of sedentary life, we don't use it to, is a big stressor. If we are human beings, we are prone to undergo swings of emotions. It is our social life that serves as the cushion and helps us in bouncing back and to come back to our normalcy. So, a happy person is a creative person. A creative person is a resourceful one. A resourceful person is a productive one and a successful one. Do you agree with me? I ask you, do you agree with me? This is the sequence. I would like to ask you one question. Before Newton, did apple go up? Before Newton, it came down. During Newton, it came down. Even today, it comes down. What if the apple falls on us? If it falls on me, if I am hit, I say, Abba. When I look at the apple, I say, Abba. Then next minute, I'm hurt. We don't think, why did it come down? Why did it go up? Education is learning to think. Life is learning to think. Are we thinking? That's the question. It's not our fault. Our education system is such. Syllabus, coverage of syllabus, classes, study hours, examinations, evaluation. Again, this is the process. Even I asked law students, how is your education? Do you have any idea how would be the profession? Suppose you read the news, you have gone to YouTube channel and studied about driving. They explain very well. Driving is very simple. Give the ignition, car starts, apply gears, release the clutch, it moves on. వచ్చేసింది డ్రైవర్ అని కార్ తీసుకొని రోడ్డు ఎక్కితే కారు రోడ్డు మీద వెళ్తుందా, కాలంలోకి వెళ్తుందా? కాలం ఉంటే దాంట్లోకి వెళ్ళి ఆ జనం మీదకి వెళ్తుంది. సో bookish knowledge is not everything. Unless juniors learn from the seniors. With a view to learning on their own as well. Everybody is not like Nada Srinivas Garu or Rama Garu. నేను ఒక అసిస్టెంట్ అడిగారు, మీ సీనియర్ అట్ట ఏం చెప్తావు రాదు అన్నాడు. అది ఇప్పటికి అది దగ్గర 3 సంవత్సరాల నుంచి వెళ్తున్నా ఒక్క ముక్క చెప్తా ఉంటాం నా చేతి కళ్ళు వేస్తాడు తగిలి మరిస్తాడు కానీ అన్నాడు. నేను అడిగేవాడిని, అరే నువ్వు ఎప్పుడన్నా అడిగావా అని. వాడు అడగనిస్తేగా అన్నాడు. వాడు అడగలేదు, నువ్వు అడగాలి వద్దా. సో సెల్ఫ్ డ్రైవ్, attitude to learn. Everything doesn't come from mouth. One can observe, one can learn things. One takeaway point I want to submit is, if you are happy, you are healthy. If you are healthy, you are resourceful, you are creative. If you are creative, you are resourceful. If you are resourceful, you are productive. Newton thought, why did the apple come down? When you study a principle, laws are so scrupulously made. I have listened to since morning. They're scrupulously made, amazingly made. What's the application? Then why are varying verdicts? ఒకే కేసులో ఒక కోర్టులో ఒక జడ్జిమెంట్ వస్తుంది, ఇంకో కోర్టులో ఇంకో జడ్జిమెంట్ వస్తుంది. ఆ పై కోర్టు ఆయన అసలు ఈ జడ్జి బుద్ధుందా లేదా అన్నట్టుగా తీర్పిస్తాడు. So it depends upon the application, not the letter. What's the spirit of the letter? What's the spirit of letter? What is its real meaning? Unless we get the real meaning of the verbatim, the law, we will not get it. Superficial application will not help. We need to think. Next please. I submitted that health and happiness are important. What is the present state in India? 1 in 5 urban Indians are obese. ఎంత అయిపోతున్నారు. కాలేజీలో మెట్లు ఎక్కేటప్పుడు నేను మామూలుగా ఎక్కుతుంటా, వాళ్ళు పట్టుకుని ఎక్కుతుంటారు పిల్లలు. ఓ ఫ్లోర్ ఎక్కి ఆగి ఎక్కుతుంటారు. వాళ్ళని చూస్తే ఏదో దంతా ఉంటాడు. ఆడపిల్లలంటే మగపిల్లలు, అరే అంత అయ్యో ఎంత దంట పొందుతురా అంటే చాలా కోపంగా చూస్తారు. ఒబేసిటీ అండ్ దెన్ హైపర్ టెన్షన్, 1 in 5. Almost 12% diabetic patients. మనం జనాభాలో నెంబర్ 1, డయాబెటీస్ లో నెంబర్ 2 ప్రపంచంలో. We have these records now. And unfortunately, psychological problems are on the rise. We find psychological problems very young, in the very young stage. ఒకటి కాళ్ళు ఒకటికి తగిలిందని ఇద్దరు తిట్టుకున్నారు యాక్చువల్గా జరిగినాడు. అండ్ దెన్ చూసినాడు, అన్నాడు తగిలినాడు, ఇందాక చూడక తండ, ఇప్పుడు మళ్ళీ అదంట అన్నాడు వాడు. తండ్రిదే అన్నాడు వీడు. ఇక్కడ నుంచి సేమ్ షిఫ్ట్ అయింది గ్రౌండ్ లోకి. కొట్టుకున్నారు. వాళ్ళు తలకాయ పోయింది, వాడు ముక్కు పోయింది. షార్ట్ టెంపర్. రీజన్ psychological disorder. These cases are on the rise. ఆడపిల్లలు సార్ నిద్రపట్టట్లేదు సార్ అంది ఒక అమ్మాయి. ఎందుకమ్మా? నా బెంచ్ లో పక్కన కూర్చుంటాం చూడు సార్, అదే కారణం అంది. డిసార్డర్, సైకలాజికల్ డిసార్డర్. They appear to be small, but they have greater implications. Almost 20% of Indian population, particularly youngsters, suffer from mental disorders. 5.6 crores Indians suffer from depression. 3.8 crores from anxiety disorders. This is the report by WHO on 7th October 2022. Next. Now, I come to today's topic. There is a solution to this. People who might be in any profession can be happy. There is a way to be happy, and it is free of cost. It is non-interference of any external chemical. It's free. బుద్ధుడు చాలా సంవత్సరాలు ఆఫ్టర్ మెడిటేషన్ penance became Buddha. ఏందనుకున్నానంటే there is sorrow in the world. There is a reason for sorrow. There is cause. It can be removed, and there is a way to remove. This is what Buddha said. అట్లాగే 4 న్యూరో కెమికల్స్ గురించి నేను ఈరోజు మీకు పరిచయం చేయబోతున్నా. These are neurochemicals. By the word, when we say neurochemical, it means they are the chemicals produced by our brains in our body. And these neurochemicals interact, they pass from one neuron to another and they communicate. Intra-communication happens. First one of these neurochemicals is dopamine. Second one is oxytocin. Third one is serotonin. And the fourth one is endorphin. First one, please. Thank you. Second one. Thank you. Third one. Thank you. Fourth one. Now abbreviate. Find the first letters. D O S E. Not that you do not know. I find some of them are dosing. So I asked. Thank you. Now what's the word? Dose. There is a dose for happiness, and this dose comes from within. It is not chemical that needs to be administered or injected. It's not a tablet to be taken. It is a way of thinking. It is a way of living life. So let us understand what are these neurochemicals and how and when does our mind produce these? Let us have a look at. Next one, please. First one is dopamine. Read the first one. Dopamine controls many functions including behavior, emotion, and cognition. Sorry, it's a neurochemical. Behavior, we see normal behaviors, we see abnormal behaviors, we see irrational behavior before as we come across all these people. Why this variance? And the emotions also. ఒకటి సంతోషం వచ్చిందనుకోండి, పక్కన ఎవడుంటే వాడి మీద బయట కొట్టి ఆనందిస్తుంటాడు. ఒకడేమో సంతోషం వస్తే దిగిసిపోయి ఉంటాడు, తోటి మాట్లాడు. ఒకటి కొద్దిగా దుఃఖం కలిగింది అనుకోండి, కనపడినోడి కల్లా చెప్పి ఏడుస్తుంటాడు. అరే దీనికి ఎంత బాధపడాలా అన్నారు అనుకోండి మీరు ఒక ఫ్రెండ్గా, నువ్వు అట్టగే చెప్తావు, నా పరిస్థితుల్లో నువ్వు ఉంటేనా అంటాడు. ఏంట్రా నీకు వచ్చిన సమస్య? పొద్దున మా ఆవిని ఇడ్లీ వేయమంటే పూరి చేసింది అంటాడు. వాడికి అది అంతర్జాతీయ సమస్య. అది కాదురా సమస్య అంటే ఊరుకోడు. Why this? Dopamine fluctuations cause these things. Cognizance. Cognizance is the way we understand things. Earlier you listen to one justice talking about witnesses. We see, we hear, we taste. Okay, how do you understand that? To understand cognizance, I tell you a thing. ఒక అడిక్షన్ క్యాంప్ పెట్టే డాక్టర్ తాగుబోతని పిలిచాడంట. వాళ్ళకి చూద్దామని, మీకు అందరికి తెలిసి ఉంది కథ. 2 గ్లాసుల్లో గాజు గ్లాసులు పెట్టాడు టేబుల్ మీద. గ్లాసులు చూడంగా తాగుబోతులు అందరూ బాగా సంతోషంగా ఉన్నారు. ఆయన ఒక దాంట్లో నీళ్లు వేశాడు. ఏది నీళ్లు పోస్తాడు అనుకున్నాడు. 2వ దాంట్లో ఆల్కహాల్ మందు వేశాడు. చాలా హ్యాపీగా ఉన్నారు. 2 పురుగులు తీసుకొని 2 ఒకే రకం అని దాంట్లో వేశాడండి. బంగారం వంటి మందులో వీడేం పురుగు చేస్తాడని బాధపడ్డారు. Now look at these two. The one in the water is healthy, is happy, is swimming, and the other one in alcohol wriggled, struggled and died. ఆయన అడిగాడు, అర్థమైందా? ఓ బ్రహ్మాండంగా అర్థమైందా? నిజంగా అర్థమైందా? అర్థమైందని చెప్తున్నాగా అన్నారు. సో ఒక పిలిచి ఇక అర్థమైంది చెప్పు రారా. వాడు వచ్చి, ఈ డాక్టర్ మహానుభావుడు ఓ గొప్ప సత్యాన్ని మన కళ్ళ ముందు ఆవిష్కరించాడు. ఆల్కహాల్ ఎంత మంచిదో చెప్పాడు మనకి. రోజు 3 పూట్ల తాగండి, పొట్టలో పురుగులన్నీ చచ్చిపోతాయి. If your mindset is not right, you don't understand things in their right sense. You misinterpret them. You understand in the other direction. ఒక గాజులో మంచి నీళ్ళు, ఒక గాజులో ఆల్కహాల్ పెట్టి అది గాజులు తీసుకొస్తే గాడిద ఏం తాగుతుంది? మంచిని తాగి వెళ్తుంది. కాంబినేషన్ సరిగ్గా నేను అడిగా అనుకోరా, ఏం చేసిందని, గాడిది కదా మంచిగా తాగుద్ది అంటాడు. అది మనుషులు అయితే అది తాగాలని. If your mind is not right, what your senses crystal clear convey, you misunderstand. You give wrong interpretations. Precisely this is why dopamine is required. It's dopamine that enables us to behave well, to think well, to understand things in the right spirit. And how do we get dopamine? When we do small things and when we enjoy our doing, మనం ఇవాళ చేసాం అనే సంతృప్తి, when you feel dopamine is released. And when others appreciate you, dopamine is released. Radha Srinivas garu, Ramarao garu are doing an excellent session. ఇది చెప్పగానే వాళ్ళకి మైండ్ లో డాక్యుమెంట్ బ్రెయిన్ లో డాక్యుమెంట్ రిలీజ్ అవుతుంది. దే ఫీల్ హ్యాపీ. అయితే మనం ఎట్లా తయారయ్యాం? భూమండలం మీద ఎవరిని అభినందించాం. ఒకవేళ అభినందిస్తే వాడు పెద్దడు అవుతాడేమో. మనం ఎవరిని అభినందించం, ఎవరు మనల్ని అభినందించరు. This is why presently housewives are very much unhappy at home. They do a lot of work, but without any appreciation. ఏం పోయింది? ఒక రోజు కూర బాగుందని చెప్పొచ్చు కదా. అది ఏదైనా కొత్త చీర కొనుక్కుంటది, కొనుక్కొని మీరు చూసారో లేదని అది దిగుతూ ఉంటుంది. చెప్పండి ఏం పోయింది బాగుందని. అక్కడ కూడా తీసినాడు తను ఎందుకు? ఒకడు వాచ్ పెట్టుకొని అంటుంటాడు, బాగుందో వాచ్ అని చెప్పండి ఏం పోయింది. వాళ్ళు ఈ డోపమైన్ రిలీజ్ అవుతుంది. వాళ్ళు మనకి ఎప్పుడో అప్పుడు కొట్టాడు ఏదో ఒకటి. We have become stingy in this aspect. Remember, there is difference between appreciation and flattery. Flattery వేరు. ఫ్లాటరీ అంటే లేని ఉన్నట్టుగా పొగట్టం. అక్కడ పైన చూడండి, ఎవడన్నా నువ్వు బాగా ఎథ్లెటిక్ గా ఉన్నావు, హెల్తీగా ఉన్నావు అంటే బాగానే ఉంటది. అసలు హెర్క్యులస్ తర్వాత నువ్వే ప్రపంచంలో అన్నాం అనుకున్నా నిజం అనుకుని తన్నులు తింటాడు. తర్వాత వచ్చి మనల్ని అంటాడు. We must be realistic. Appreciation is not flattery. These two are two different things. So, dopamine is a neurochemical our brain releases when we feel proud of doing something, when we perform something, when we buy something. Today is a holiday. Many young lawyers are elsewhere partying. You are here. If you feel that you are doing a good thing by attending this orientation program, that sense of satisfaction releases dopamine. When we appreciate others, not flatter others, dopamine is released. You don't have to spend a single pie for this. A little bit change in our way of thinking is enough. So, what's this neurochemical, please? Next. Oxytocin is also called love hormone. Suppose something very tragic happened in your life, a very big tragedy. In that moment, hug an infant, a child. Keep the child close to your heart. Hug. Gone. Your grief will disappear within no time. Oxytocin is also a neurochemical. Our brain releases it. And when does this happen? When we have feelings of love, affection. ఈ రెండు ఈ మధ్య మానవ జీవితాల్లో వంటల్లా, ప్రేమ వంటల్లా, విమానం వంటల్లా. నాకేం పని అంటున్నారు. పిల్లలనేమో ప్రేమ అంటే హీరో హీరోయిన్ బూతులు లాక్కోవటం, అదే ప్రేమ అనుకుంటున్నారు వాళ్ళు. హీరోయిన్ విల్ బి ద ఓన్లీ డాటర్ ఆఫ్ మల్టీ-బిలియనీర్ ఇండస్ట్రియలిస్ట్. ఆమె హెలికాప్టర్లు అట్లా తిరుగుతా ఒక ఓవర్ బ్రిడ్జ్ పక్కన గంజాయి తాగేవాడిని చూసి ప్రేమిస్తుంది, లేకపోతే వైస్ వర్స. ఇది సినిమా, అది లవ్. We shall understand love is the finest of human emotions. It's not infatuation, it's not physical attraction between a boy and a girl. It's a feeling, a finest emotion. As a human beings, when we have this emotion, love and affection, our brain releases oxytocin. During COVID, I was in US. Our neighbor was an American lady. She lives alone. Whenever she came out, there was a dog with her. I asked her, and she talks about that pet more than she talks about her children. I asked why. Do you have children? Yes. Where are they? They are there. Away. They are living their lives. Why do you talk about it? Because this sits in my lap. This is always with me. I feel its presence day and night. It gets attached. This is why if you happen to go to US, you find a pet in every family, either dog or cat. Precisely because of this. They feel loud. That makes them happy. Hugging for 20 minutes releases oxytocin. అందుకని రోజులో కనీసం ఒక 20 సెకండ్లు ఎవరినో ఒకళ్ళు వాటేసుకోండి. ఆక్సిటోసిన్ రిలీజ్ అవుతుంది, హ్యాపీగా ఉంటారు. ఎవరినో ఒకళ్ళు అనగానే మీకు అర్థమైనాడు. నా ఉద్దేశం అది కాదు. మనం తండ్రి తిన్న ప్రోగ్రాం పెట్టుకోవద్దు. నెక్స్ట్ వన్ ప్లీజ్. Read this. First one. All of you, please. Read this. Serotonin is released when we benefit others. గుంటూరులో నాకు తెలిసిన లాయర్స్ లో బాగా సక్సెస్ఫుల్ అయిన లాయర్స్ ఎవరు అంటే, నేను ఈ ప్రొఫెషన్ లో జనానికి ఉపయోగపడాలి అని పనిచేసిన వాళ్ళు. ఒకళ్ళ పేరు చెప్తే ఇంకొకళ్ళకి అవమానించినట్టు అవుతుంది. ఒక జనరేషన్ ఉన్నారు. ఐ టెల్ యూ ఎన్ ఎగ్జాంపుల్. ఒకసారి ఏదో కేసులో, నేను స్టూడెంట్ డేస్ లో ఉన్నప్పుడు పోలీసు వాళ్ళు కేసులు పెట్టేవాళ్ళు. ఒక బాడీ బిల్డర్ ఉండేవాడు, ఎస్ఐ. ఆయన మంచి బాడీ బిల్డర్. నేను సన్నగా ఇట్టు ఉండేవాడిని స్టూడెంట్ డేస్ లో. నా మీద కేసు పెట్టాడు ఆయన, అటెంప్ట్ మర్డర్ అని. నేను అడిగా, అసలు నేను ఎట్లా చంపుతాను, ఇదే అన్యాయమైన కేసు అని. అంటే పోనీ ఇది మార్చి గంజాయి కేసు పెట్టమంటావా అన్నాడు. వద్దులు అదే తగలబాటు. I was produced in the court of law. అక్కడ జడ్జి గారు అడిగాడు, ఆయనకు అర్థమైంది ఇది ఫాల్స్ కేసు అని. అడిగి జామీన్ తెచ్చుకో, బెయిల్ తీసుకున్నా అన్నాను. మీరు తెలుసుకోవాలి నాకు లా ఇట్స్ అన్నారు. నేను జామీన్ తెచ్చుకున్నాను, ఇది తప్పుడు కేసు, వదిలితోటి లేకపోతే లేదా. అప్పుడు లాయర్ గారు ఉన్నాడు అక్కడ. వాళ్ళు మనం ఎక్కడున్నాడు, పెద్ద అంటారు అని. ముందు చిన్న తెలియదని ఆయన బెయిల్ పేపర్స్ అరేంజ్ చేశాడు. నా జేబులో ₹1 కూడా లేదు. అట్లాంటి లాయర్లు ఉన్నారు గుంటూరు. వాళ్ళే సక్సెస్ అయ్యారు ప్రొఫెషన్ లో.
So, as a lawyer, when your priority is to help human beings who are in distress, who are helpless, who are in need, you become an excellent lawyer. There is no doubt about it. Today, the country has become a heaven for rogue celebrities. The country has become a hell for a great majority of law-abiding common people. I repeat, the nation has become a heaven for a few rogue celebrities. The nation has become a hell for the tax-paying, law-abiding, vast majority of people. As lawyers, we have a lot of work in this area. Get into them, acquaint with them, understand their problems. Take the spirit of constitution. Question the bureaucracy, the judiciary. Give them right interpretations. This is the spirit of constitution. And your behavior is contrary to this. Your attitude is in conflict with the spirit of constitution. You give voice to the voiceless people. There is a lot of work in this regard. And when you start doing this, your brain releases serotonin, you will be happy. And there is anatomy here. This wonderful serotonin, brain chemical serotonin, is stored in the intestines, where digestion happens. Today, from the age of 25 onwards, many people suffer from indigestion. చక్కగా ఎవరికన్నా మెయిల్ చేయండి. సెరటోనిన్ ఇంటెస్టైన్ లోకి వస్తుంది, తిన్న శుభ్రంగా అరుగుతుంది, ఆరోగ్యంగా ఉంటాం. Let us help others. Let us benefit others. As legal professions, we can do that. Professionals, we can do that. So let us do that. Next one. This is the last one of the dose. What is this? This is endorphin. This is also a neurochemical. It is released when we exercise. When we eat also, endorphin is released. Earlier somebody was telling, yes, Ramaraj was telling, eat lunch as much as needed. We are making our stomach a dustbin. ఒంటికి ఎంత అవుతుంది, ఏదో ఒకటి లోపలేద్దాం. మళ్ళీ సాయంత్రం ఏమైందండి, ఏదో ఒకటి లోపలేద్దాం. ఈ లోపల వేసి దాన్ని డస్ట్బిన్ చేసి మన శరీరాన్ని ఊబకాయం చేసి doing exercise helps our brain release endorphin. And there are various types of exercises. Aerobics are there. Exercise must be age specific. అంతేగాని ఇవాళ ప్రోగ్రాంలో వాళ్ళు సాయంత్రం ఏదో ఏరోబిక్స్ పెట్టేది కాలు తలెత్తారు అని మనం ట్రై చేయకూడదు, కాలు రూపారు. It must be age specific. Whatever our body permits, if we do, if we exercise, endorphin is released. And studies say sex also releases endorphin if it is legal. Sex between wife and husband
releases endorphin, whereas illegal sex causes release of adrenaline. Because the sense of guilt haunts us. So, any physical exercise helps our brain release endorphin, and we can get it free of cost. It keeps us happy. Next, please. Yoga also helps. Ramareva announced after this there will be yoga. Some suggestions. Yes, it is. Today the world accepts the strength of yoga. It keeps us physically and mentally healthy. Yoga has answers where $1 million pharmacy cannot answer. It is proven. American economy is driven by pharmacy mafia. Today they say one thing, tomorrow they say another thing. They say all happens in the name of research. Whereas yoga is proven. It is Indian way of life. It has no side effects. It keeps our mind pleasant and happy, our body fit and healthy. So let us practice. They also improve our concentration. This is amazing. Many of you have been seated since morning. In classes, it doesn't happen. After 15 minutes, students eagerly wait for the bell. ఒక్క 20 నిమిషాలు అవ్వగానే వీడు పొద్దున్న వచ్చాడు పోతాడో పోడు అని మొదలవుద్ది వాళ్ళకి ఆందోళన. కాన్సన్ట్రేషన్ ఉంటుంది. యోగా హెల్ప్స్. నెక్స్ట్ ప్లీజ్. Well, you might say after my session, వాళ్ళు ఏదో డోస్ అని చెప్పాడు, బాగానే ఉంది, ఈ అయ్యన్నా సచ్చానా, బయటికి వెళ్ళంగానే ఎండ, ఇంటికి వెళ్ళంగానే మా ఆవిడ, ఇంకెక్కడ నా జీవితంలో సుఖం సంతోషం అని ఇంకో కాంగ్యం 48 డిగ్రీలు వచ్చింది వాళ్ళ బయట, ఇంటికి వెళ్ళంగానే మా ఆయన దరిద్ర బాగు వేసుకోండి అన్న దోసి 15 అంటాడు. All this is peripheral. Unless our mind accepts external messages, things happen, but the message things give is reception specific. How do you translate those messages? It is our mind that determines this. So, financial problems are real. Job insecurity is real. Health problems are real. Uncertain future is the ground reality. Family problems are there. Conflict in workplaces. రోజు మీరు కూర్చున్న కూర్చుల్లో ఇంకోటి వచ్చి కూర్చొని ఉంటాడు, మీ చర్యకు వచ్చి మీరు ఎవరి కోసం కూర్చొని ఉంటారు, వాడు వచ్చి వేరే వాళ్ళతో మాట్లాడుతుంటాడు, మీరు వెళ్ళమంటా ఉంటుంది. దీస్ థింగ్స్ హ్యాపెన్. అన్నిటికంటే ప్రమాదకరమైన ఇబ్బంది ఏంటంటే ఇన్సెన్సిటివ్ బాస్. ఒకళ్ళు పరమ తెక్కోళ్ళు ఉంటాడు, వాడికి ఆ తెక్క ఎట్లా దాంతో అనేక మంది సఫర్ అవుతూ ఉంటారు. అంటే ఈ కాంటెక్స్ట్ లో చెప్తే బాగోదు, అందుకని నేను వేరే కాంటెక్స్ట్ లో ట్రాన్స్లేట్ చెప్తా. ఇక్కడ బాస్ ఎవరో మీకు తెలుసు, అందుకని ఇక్కడి నుంచి నేను మా కాలేజ్ కాన్సెప్ట్ లోకి వెళ్తా. ప్రిన్సిపల్స్ ఉంటారు. ఇందాక నేను చెప్పానే ఆ ఫేస్ లో ఏ ఎక్స్ప్రెషన్ ఉండదు. Suppose if you are approaching that fellow, వీడు లీవ్ అడగటానికి వస్తున్నాడు కాబట్టి మనం అటు తిరిగి కూర్చోవాలనుకుంటా. మీరు ఒకటి చెప్తే వాడు ఇంకోటి అర్థం అవుతుంది. ఇన్సెన్సిటివ్ బాస్. ఆల్ దీస్ థింగ్స్ ఆర్ రియల్. రామారావు, ఐ అండర్స్టాండ్. Their own problems in life. జయరాజ్ అనే ప్రజా కవి శిల్ప నీవే, శిలి నీవే, శిల్పం నీవే అని ఒక పాట రాశాడు. శిలా నీవే, శిల్పి నీవే, శిల్పం నీవే. జేసుదాస్ పాడాడు ఆ పాట, అది వినండి. రేపు పర్ఫార్మెన్స్ కూడా ఉందని చెప్తున్నారు శ్రీనివాస్ గారు. ఎక్సలెంట్ సాంగ్ అది. ఈరోజే వండర్ఫుల్ వండర్ఫుల్. అందుకని అంతా మనమే, మనం ఎట్లా అర్థం చేసుకుంటాం అనే దాన్ని బట్టి మన లైఫ్ ఉంటుంది. డోస్ కెమికల్స్ అనేది రియల్, వాటితోటి మనం హ్యాపీగా ఉండొచ్చు. ఎన్ని సమస్యలున్నా మనం పక్కవాడిని అభినందించవచ్చు, వాడు చేసిన మంచిని. డోపమైన్ రిలీజ్ అవుతుంది. మనుషుల్ని మనిషిగా ప్రేమించవచ్చు, ఆక్సిటోసిన్ రిలీజ్ అవుతుంది. మనకి చేతైన ప్రయోజనం ఇతరులు చేయొచ్చు, సెరటోనిన్ రిలీజ్ అవుతుంది. ఎక్సర్సైజ్ చేయొచ్చు, ఎండార్ఫిన్ రిలీజ్ అవుతుంది. దీస్ న్యూరోకెమికల్స్ హెల్ప్ us live happily. Next one. So, and look at her. She might have experienced so many problems in her life, but read her face, so amazingly cheerful. And if we can be so, we'll be happy in life. We'll be successful in life. Our life will be meaningful. I'm not talking about riches. I'm not talking about social positions. I'm talking about a default characteristic that we should develop in life, that is being happy, being cheerful. Next one. And to be happy, I'm concluding, forgiving others is important. ఈ మధ్య సీరియల్స్, తెలుగు సీరియల్స్, అందరూ పిల్లలు లేడీస్ గన్ను తీసుకొని తిరుగుతుంటారు. ఒక ప్రతిజ్ఞ చేస్తాడు, ఆ వంశం సర్వనాశనం అయ్యేదాకా నేను స్నానం చేయడానికి. ది సెన్స్ ఆఫ్ నాన్ సెన్స్. మీరు కులిపోయిన టమాటాలు, పొటాటోస్ జైల్లో పెట్టుకొని తిరుగుతానంటే అది తెక్క కాకపోతే ఏంటి? ఇల్ ఫీలింగ్స్ ఫర్ అదర్స్, సెన్స్ ఆఫ్ టేకింగ్ రివెంజ్ ఈజ్ నథింగ్ బట్ carrying rotten tomatoes with potatoes with us. Let us be forgiving. ఎంత క్విక్గా మర్చిపోగలిగితే, ఎంత క్విక్గా క్షమించగలిగితే అవతల వాళ్ళని మనం పసిపిల్లల్లాగా సంతోషంగా ఉండగలుగుతాం. అండ్ మోస్ట్ ఇంపార్టెంట్ థింగ్ విత్ దిస్ ఐ కంక్లూడ్, లెట్ us greet people. Let us say good morning. Good morning. Afternoon. Afternoon. Good afternoon. Evening. Night. No. Even if it night falls, we shall say good evening. If we say good night, they say good night. It's a parting courtesy, not meeting greeting. Let us greet from the bottom of our heart with a cheerful face, whether the other person is prince or pauper, rich or poor, highly placed or lowly placed, whether scavenger or the President of India. Let us greet every human being on par with a cheerful face, with a good feeling for others. We'll be happy in life. Thank you very much.
Thank you, sir. Good evening, all of you. So, అందుకని చెప్పారే మనం we'll start practicing. At least these 3 days, we'll practice and try to have those. As he suggested, maybe if the interest you serve, if it is your objective, everything will follow. But not fully. Be practical. Because if you do that, we will not get required the ghosts in the house. We will ultimately balance in the life. While we are working for ourselves, working for our family, and we should also think of society, common interest, professional interest, society, so that unless there is a good society, we cannot have a good environment. Thank you, sir. Thank you very much. We will try to practice the 3 days. I request Justice Kodandram come on to the dais and hand over the memento. Even before he became justice, he used to have talk like this. He always try to motivate and fail. That is a different aspect.
Wonderful, sir. Thank you very much. Thank you.
With this, all the sessions of the day successfully over, having to advantage a dose also. Now, just now, another aspect he has highlighted, health. Health is important. So there is a health camp all these days with us. That side, 3 days they are available here. Reports we will try to give you before you leave from here. There is a blood samples they will collect. A doctor is also there, team is there. And then after clinical necessary, they will prepare a report, ECG, including ECG also. Today it may not be there, from tomorrow ECG also will be available. Please have that benefit. Have a cup of tea and give your samples. Slowly, one by one, no problem. Anybody remaining, they will be here up to 8 o'clock. And you can finish giving your blood samples. And thereafter, just now, said is like that same person who written and he will sing before all of us, and he will be entertained. He will forget everything which strain and pain that we have undergone till now. Thank you. Take a half an hour break. Half an hour break. Have a tea. Consume the tea, give your blood, and come inside.
Last third.